Anybody need eye wash?
I think we're all good.
All right.
Let's get to the next one. Huh? The next one. Where is it?
Thanks. Keep covering it. Better? Okay. Better than you, because I didn't get it as directly, I don't think. But I'm appalled at the fall of democracy. You live near here? You got a way to get where you need to be?
No, I live.
All right. If you know anybody here?
All right, folks, this is the scene out here in Minneapolis this morning. We are over at Park Ave in East 34th Street. There was ICE activity in the area and quite a few confrontations just occurred here. Multiple arrests made.
Anybody need an hydrant?
Tear gas deployed. Pepper spray. It appears the federal agents have left this immediate vicinity for the time being here. It is currently 10:30 a.m., Tuesday, January 13th, 2026. Going to cut the stream here. But keep tuning in. If you're not already subscribed or following, we're live over on YouTube, on Twitch, on Facebook, Rumble, and X. Definitely appreciate y'all giving those a follow and for keeping up with the coverage that we got coming out. So thank you for tuning in, and there will be more to come. More coverage to come.
Cut the stream here? What do you mean, bro? Super Soy Soldier. Wildman Actual, good to see you, man. I haven't seen you in a minute. Good to see you, brother. What do you mean you're cutting the stream here? Why would you cut the stream here? Out of all the times to cut the stream, now is not the time. Hang on. SCOTUS hearing on transgender athletes in school sports. All right. I mean, while I'm live, let's find some shit to do.
Not participate on the girls' team.
So you're just a birth sex male who has all the advantages of birth sex male hormones, and can the school bar him from the women's team? Yes, they can.
But that person, is that person not a woman in your understanding? If the person says, I sincerely...
All right, I'm going to try to figure out something else going on, but this is actually quite entertaining.
Is that person not a woman?
I would respect their self-identity in addressing the person, but in terms of the statute, I think the question is, does that person have a sex-based biological advantage that's going to make it unfair for that person to be part of the women's team? And that's the rationale for the regulation, and so that's the way we would be testing that hypothetical.
Well, the reason I'm asking has to do with discrimination on the basis of transgender status. So what you seem to be saying is, yes, it is permissible for the school to discriminate on the basis of transgender status, because if this person is a trans woman, a trans girl, and is barred from the team, from the girls' team, then that person is being subjected to differential treatment based on transgender status, right?
Well, that would be, then the question would be whether it was, the scrutiny would be satisfied. So from our perspective, that would be a transgender classification. It would get heightened scrutiny, and it may be satisfied here because of the need to have, to curtail unfair athletic advantage. That would be the analysis. We are not pressing in this case the notion, and the case does not require the court to decide whether transgender women who've gone through puberty and have not suppressed their testosterone would be able to play on a men's team. And the record here is a preliminary one where that doesn't present that question for the court.
And this does present a particular factual situation.
Your Honor, by transgender women, do you mean
to the broader issue that a lot of people are interested in? There are an awful lot of female athletes who are strongly opposed to participation by trans athletes in competitions with them. What do you say about them? Are they bigots? Are they deluded in thinking that they are subjected to unfair competition?
No, Your Honor, I would never call anyone that. And I think what we're saying here is that you have to, that's the reason why there is intermediate scrutiny, or even in rational review, you don't legislate based on undifferentiated fears. You base on trying to make a rational response to what is a perceived issue. I think here, although I would take issue with the notion that there was no reference to transgender individuals in the creation of this law, I really would direct the court to JA. Again, this is not about animus. I'm just saying that if you look at JA, pardon me, I need my JA 105 through 112, there are numerous references from the sponsor of the law saying the way we're going to try to protect women's sports is to not have transgender women play on the women's teams, and that was the fear that they had at the time. Again, that is not an accusation of animus. It's just a question of what was the statute doing, and then we go to the point of, does the statute survive heightened scrutiny? That would be the inquiry.
Do you think that the success of trans athletes in women's sports is proportional to the percentage of trans athletes who participate in women's sports?
I think I would direct your attention to, there's I want to make sure I have the right amicus. There's an amicus brief that talks about actually some of there are examples, obviously, of some transgender people that have participated and excelled. They actually are few and far between. You know, we have our client here who tried to make the NCAA team because of the injunction. She was too slow. She played club soccer, club running. She was even an officer in one of those clubs, just doing what you would hope a college student would do. You'll hear from my colleague about the other case. But I do think that, and there's a brief that you
imagine if the Supreme Court
of showing that's a bit
a lawyer saying, well, she tried to make the team, but she was too slow.
To the extent, I mean, we've already covered that transgender people are a slice of the population, but a small slice. I think the state, if there were actually
she tried to make it, but she
fully
sucks.
overrun by an outbreak of
and by the way,
people,
she
that might be a different factual situation in the end of the day, and we understand that there were legislators who were concerned about that. The legislative history makes that clear here, but that wasn't the factual basis before the court. If there were actually a threat to women's participation in women's sports, that could be a different analysis, because obviously the goal of sex equality in sports is a very important goal. We don't take issue with that. We just would say that I think this is an important moment to just take a step back and say, is this law actually responding to a problem in a rational manner, or is it actually overreacting on the presumption that transgender women are categorically going to be strong athletes when that's not the case?
Well, just to put the big picture, and you know this on the table, and let you respond to it, but obviously one of the great successes in America over the last 50 years has been the growth of women and girls sports, and it's inspiring. And there's some states in the federal government and the NCAA and the Olympic Committee, so these are a variety of groups who study this issue think that allowing transgender women and girls to participate will undermine or reverse that amazing success and will create unfairness, because you said if large numbers, well, for the individual girl who does not make the team or doesn't get on the stand for the medal or doesn't make all league, there's a harm there, and I think we can't sweep that aside. And I think that's what's undergirding some of the concern in this big picture, and there are harms on both sides. So I completely understand that, but I just want to let you respond to that, because that is, the NCAA, the Olympic Committee, a lot of states, federal government. That's a lot of people who are concerned about women's sports and think this raises a big problem. And I just want to make sure you can explain that.
Thank you, Your Honor. And just to be clear, Title IX is a huge triumph, and I'm a veteran of women's sports myself. I'm glad it exists. It's made a huge difference in our society. That's not what we're talking about here. But I do think, to the point of, for the podium question, I think the question is there an unfair biological advantage? That would be the question. So I understand the point. If there is somebody who's coming in with an unfair biological advantage, that would undermine the entire point of separate sports in the first place, which was to allow women to have a place to thrive, to be strong, to win, not to just be the B team. The question in this case is if the person had actually mitigated their sex-based advantage, which maybe interestingly, maybe counterintuitively, actually is more about circulating testosterone after puberty than a lot of the other things we might think are sex-related, then that girl that's come in second to a transgender person that's mitigated actually may just have come in second because the transgender person was similarly situated, but was stronger in that one competition. That's why we are here not proposing a rule of absolute inclusion, but saying that in the case with people like our client who have mitigated, their exclusion doesn't match the statutory interest.
Counsel, can I ask you a question about analytically in the discrimination on the basis of transgender status? Since trans boys can play on boys' teams, how would we say that this discriminates on the basis of transgender status when its effect really only runs towards trans girls and not trans boys?
We understand the point, and I think that might be relevant to for example, animus point, right? There were not a complete exclusion of transgender people, there was an exclusion of transgender women. But I think on that piece, this court has never required the whole class to actually be excluded to look at the cases to whether the exclusion of a subclass was...
I'm talking about for triggering intermediate scrutiny if transgender status is a suspect class.
Right, so like Craig B. Bourne, for example, that's the one about the men that couldn't get the 18 to 20-year-olds, right? That wasn't all men, it was a subset of men, and yet the court still viewed that as a sex classification subject to heightened scrutiny. And likewise here, even though it's just transgender women, in our view, that are being barred and not transgender men, that also would trigger heightened scrutiny. And I think there's the Rice v. Cayetano case from 2000. There's other examples of the court making clear that just because a subset of the protected class is being excluded, you still would apply heightened scrutiny.
Another question about the science. So you were talking about circulating testosterone being kind of the marker. Idaho is saying, well, that's not the only indication. There are other, when I asked the question about 6-year-old teams before that there are other just kind of genetic hardwired differences, maybe in size, et cetera, that don't have to do with circulating testosterone. Is it your understanding that testosterone is it?
So, and my colleague who will present the argument in the next case, is that the record there was more about prepubertal and puberty. Right. I think that the 5% even is not clear whether that's just environmental or biological, actually.
Right.
But I do think, so there are other things that I think, like height, bone size, there have been some other discussions of this. This is an underdeveloped record, by the way. This needs to go back and have a full trial, except that it's moot. But I think the point there is that, no, I'm not trying to make a point on that. I'm not trying to pretend that I'm going to have a trial when we're not. Yeah. But I think the point is that sometimes counterintuitively, it's like having a larger frame, but not having the muscle and the testosterone to drive it could actually put the person in a worse position. And that's a study that was commissioned by the Olympic Committee. It's footnote 6 of our brief. Indicates that actually it could be put the transgender woman at a disadvantage if they happen to have larger bones and less testosterone or muscle to drive those bones.
Last question. So below, as I understand it, your client challenged the verification procedures.
Yes.
Except when we were talking about how this might be administered, I understood you to say that it would be by checking testosterone levels, because it would be okay to say, to Justice Alito's hypothetical about the cisgender male who has taken no steps and who is now trans to exclude that person. But would that be an invasion? Would that be a violation itself or too invasive to require someone to, and maybe not just once, but maybe to periodic testing to make sure that the circulating testosterone was low enough? Why wouldn't that be invasive?
So that's an ordinary blood work that a transgender person would get, and that's why I think it's of the nature of the minimal burdens, like in Nguyen and the other cases where the court has said intermediate scrutiny applies, and you actually can, if there's minimal things you have to do to make yourself fall in the category that we want to keep protected, we can require that of you. But
didn't you challenge it?
Well, that was different actually, because the three things that you'd have to prove under the state's novel verification thing would have to be your genetic, your reproductive anatomy, which would require actually like a pelvic examination or examination of someone's, nude area. It would be chromosomes, which would require chromosomal testing. That's not what we're talking about. Or it would be endogenous testosterone. And the reason why that wasn't a problem is not because of a blood test. It's not invasive. It's because it would have required the transgender person to stop their hormone treatment to get back to an endogenous level to be able to show they're endogenous.
Okay, so the distinction between circulating and endogenous.
Right, the point was that was actually in a way, like, I'm not trying to cast aspersions, but a kind of a false requirement for transgender people because they aren't on their endogenous testosterone when they're on hormone therapy. They're on a non-endogenous medical treatment.
Thank you, counsel. Justice Thomas? Justice Alito? Sotomayor?
I'd like you to address mootness because you raised it with Justice Barrett. Is this case moot? Could you respond to the other side's positions or arguments as to why it wasn't? And how do you respond to that? Secondly, Justice Barrett did raise earlier, this law applies even to primary schools, correct?
Taking your second question first, yes. I don't think it's in the record whether or not there are any primary schools, whether they sex separate or not, but that is the law.
And so, at least as to that subgroup, no one could doubt that primary school children might have the strongest argument that there's no difference in their physical makeup that would cause harm or otherwise create an advantage, correct?
That would be our position, Your Honor. In this case, we had both our client who was at college at the time, and then we had a high school intervener who was worried about being subject to the sex verification, so we didn't really get into the building a record on the
But the point is that the law might be overbroad in many ways.
Certainly, yep.
And there's still, as you noted, Idaho is the first or the second state to pass this law?
It was the first. I mean, these cases come to you because they're early ones.
And the record here was the most underdeveloped, correct?
Including because it was a preliminary injunction. There was a substantial amount of expert material in the record that allowed the district court to make appropriate findings, but it was not the level that you build up for a trial.
And both courts said that the record had to be looked at more carefully.
Expressly, they did.
All right, so answer the mootness question.
I mean, Your Honor, all I can say is that we've tried to provide the court with accurate information as soon as it came to pass. In 2024, when we opposed certiorari, our client still was active and intending to play sports. The court granted the case. She was preparing for what she hopes is her final year of college. She was concerned about the increasing hostility and the visibility. I mean, we're here now, and that's okay. She understands she brought the case. But that was the basis for her trying to end her sports career. And it isn't contrary to what she said before. She did intend to play sports through college. Her college has taken a long time. She's now sworn she will never play sports that are covered again, and she won't do that even if she happens to somehow win this case. So that is just the truth. But whether the court believes it's moot, that's, we put the facts before you for you to decide.
How about her graduating this year? There was a suggestion she might not.
As you can tell, we have, college students have so she is trying her best to get through college. I think at this point, and I'm just basing on what I know of as to today, she's unlikely to graduate by May, as my friend said, but is hoping to make through summer credits, could graduate in the fall.
Finally, in terms of the sports teams, the Olympic team, that all happened in 2025 after our president directed them to.
We do think that's worth parsing out. Again, there's been a lot of contentions made on both sides that are extra record, but I do think a lot of those things flowed from the executive order. There were some other sports orgs that were doing different things, but I think we have to be careful not to talk about that because some of it may have been political, some of it may have been scientific, and the record really isn't fully before the court.
Justice Kagan?
Ms. Hartnett, I just want to get your understanding of what constitutional review would look like in this context? So you said it's not individual by individual. You have to come in and say there's a class that's not being treated appropriately. What is that class here?
Thank you, Your Honor. And I would say I don't think the court has ruled out the individual case. I just think we weren't presenting it that way because we were trying to align ourselves with how the court had looked at it. I think we would say we represent the group of people that do not have an athletic advantage, that have mitigated their their biological advantage of being born male.
So who do not have an athletic advantage for reasons of taking certain medications or hormones or
no sex-based biological advantage. So it would encompass both people that had gone through the male puberty and had mitigated. It would also encompass others that have not yet gone through puberty or that staved off puberty with the puberty blockers.
And as to those people, who has the burden of showing that the justification doesn't fit?
I think I think once we've identified the subclass under intermediate scrutiny, it is the state's burden to show a substantial relationship for that group, and they failed to, and that's how those other cases proceed.
You wouldn't think that because we are talking about an as-applied challenge to a law that's facially everybody can see is legitimate, that the burden should shift to you?
I don't think that's how the cases looked at it when they were assessing. They were kind of assessing whether the state had provided enough to allow the exclusion. For example, in Lair, the state had made an adequate showing to show why the parent in that case was properly excluded.
And how do you think the question of scientific uncertainty should play out in an analysis like this?
Thank you. That's a good question, and I know this was something the court did address in Scrimeti, a rational review case, but citing Carhart, which also talked about that. I think the one thing we definitely want to have is complete findings, so that's why we really were urging to have a full record developed before there were any final judgment of scientific uncertainty. I think the court has not fully grappled with what does scientific uncertainty mean and how does it come into conflict with heightened equal protection scrutiny, but I think we don't need to present that yet because on this record, there was not uncertainty. This person had mitigated, testosterone was the determinant. Maybe on a later record that would come out differently, but I don't think that.
Just play it out a little bit if there were scientific uncertainty.
I mean, if it really were an equipoise, then I think that that is a situation where I think it's still heightened scrutiny. So under heightened equal protection scrutiny, the burden is on the state to justify the law, and if they haven't been able to justify that, that usually fails. If it's really a question of they're at 50-50, do we allow the state some leeway? I don't think that's been answered in the court's cases. Normally, the heightened scrutiny controls, and there's not a deference on top of that in the equal protection context.
Thank you.
Justice Gorsuch.
Just to follow up on that, I wonder if that starts to sound like strict scrutiny, because if the point of intermediate scrutiny, of course, is some leeway for the state, not a perfect fit, at least in the facial area. But if there's scientific uncertainty about whether puberty blockers and testosterone suppressants completely or mostly or some percentage of the time eliminate all competitive advantage, some competitive advantage. I mean, you've been very careful, I think, and rightly so, to talk about mitigating advantage. But I don't know, does the state have to show that it eliminates advantage and it doesn't eliminate, some percentage of advantage remains in each individual case, or for the group as a whole? I'm struggling to understand your response to Justice Kagan on that score. Maybe I'm inartfully posing the question, but I hope you understand.
I do understand your question. I think the question is at some level, I think the question is where you have science that's developing in real time at some level, what happens, how does that dovetail with trying a state that's trying to regulate and do that? I think what we can say on this record is the categorical exclusion is really not supported, I don't think, by any science. This again was from kindergarten through college, and so there'd be some subgroups at least, and I think there has to be an effort to try to tailor it. I think here the problem was there was a reaction of transgender women, a picture of what that would be, kind of an undifferentiated fear, frankly, from the Cleburne case, and so I think
I appreciate all of that, but it seems to me from my glance at the record, and quite a record it is, and that there is a healthy scientific dispute about the efficacy of some of these treatments, and that's understandable. And I'm just wondering, how does that fit with, assume there is some dispute, and I understand the record remains to be developed further, but how does that fit with intermediate versus strict scrutiny?
At the end of the day, it's the state's burden to show a substantial relationship, and I think in the case of something where they're doing their best and have the best evidence some evidence to support what they're doing.
Some evidence, the best evidence, exactly. I mean, that's
a level of evidence that wasn't met here. So the study and the findings. I mean, the district court made a really good point. That study had actually been retracted, and it didn't pertain to transgender athletes. So in a way, this is not the hardest case. I appreciate it as a hypothetical. I guess what I would just urge in this area that's sensitive, obviously politically, but also as a matter of science, to at least let a record develop in one of these cases that lets you decide, actually, is this
I totally agree with that.
50-50 versus 80-20? That's
all right, but 50-50, does the government win? Does 70-20 the government win? That's what I'm getting at. I understand the complexity of the record and the difficulty of the science, but if we're going to have individual cases brought, that's the kind of question we're going to ultimately have to answer, not the science question, but the percentage question, if you will.
No, I understand that. I mean, VMI does provide some sort of a metric of what we would do there, which was we looked to see there were kind of evidentiary debates on both sides of that. But even if you could say that a lot of women may not have ever made the cut, the fact that there were some that did was enough to invalidate the entire policy. So I think there are ways for courts to make those judgments. And I think the court has not yet, I think, encountered a case where heightened scrutiny puts a heavy burden on the state. It's not an insurmountable one like strict scrutiny normally is. And then what happens if it ends up with the evidence being a tie or close to it when we go back to the trial court? I think that would be that would be breaking some new ground, because I don't think there's an equal protection case that decides that issue. Usually the evidence is kind of clear on one side or the other about whether the restriction is justified.
So that would remain for us to decide at a later point.
I do think that's the most prudent, but definitely on a record that's more developed, because I think I think in the end of the day it might end up being a surprise to, we don't know yet, but I think we have some good evidence that actually at the end of the day, being transgender woman, actually to the extent there are, and you repressed your testosterone, you're at somewhat of a disadvantage in many ways, because you have, again, this larger frame with weaker muscles and no testosterone.
Thank you.
Justice Kavanaugh?
Just to follow up on Justice Gorsuch's question, a broader frame about the role of this court when there's scientific uncertainty. I mean, there'll be different district courts who do different things, almost certainly in different cases, and in an area of scientific uncertainty where there's strong assertions of equality interests on both sides. And so it's going to come to this court, and we have to decide for the whole country, constitutionalize this. And I guess given that half the states are allowing it, allowing transgender girls and women to participate, about half are not, why would we, at this point, just the role of this court, jump in and try to constitutionalize a rule for the whole country while there's still, as you say, uncertainty and debate, while there's still strong interest in the other side? And I think one of the themes of your argument's been the more people learn, the more they'll agree with you. At least I've detected that theme in your argument. So why would we get involved at this point, constitutionalize?
I understand the question, Your Honor, and I do think that the Equal Protection Clause's demands have never been viewed as kind of a separate avenue from the legislative process. They can and do often coexist. And here, I think the point is we have two as-applied challenges to early laws. They have their unique cases in their own right. I don't think this court needs to set rules forever on this area. I think the most important thing would be to allow a record to develop, even in areas of controversy. And we look back at what you cited in Scrimeti, you cited Carhart. There were extensive findings. There also were findings in VMI. There were findings in Craig v. Boren. I'm learning things by reading these cases over again. There were findings in those cases. And so I think that at least before the court decides to either step back fully or to embrace its role here of providing the scrutiny that should be attended to groups when there's a worry that the democratic process isn't actually going to fairly respond to their concerns, I think the point, at least at a minimum, would be get a full record, which we don't have here. That would be my request.
Thank you.
Justice Barrett? Justice Jackson? Thank you, counsel. Rebuttal?
Thank you, Mr. Chief Justice. A few points. I heard just a moment ago that there is no real threat to women's sports. We strenuously disagree. We cite Your Honors to the UN Special Rapporteur's report that says 600 women have lost 890 medals in 29 different sports. That's what we're talking about. It is a real threat. Medical transition does not reliably suppress all male athletic advantages. I'd cite Your Honors to our record in which our expert, Dr. Brown, shows the experience of one C.C. Telfer, an elite track athlete who underwent a medical transition and whose track times did not change. That is the story in many situations, and unless we can reliably distinguish between those situations and the situations which testosterone suppression does reliably eliminate the advantage, then we can't do that. We need a broader classification, and sex is the right one. And if it were merely politically motivated, I would add we wouldn't see this same rule being implemented by World Athletics, World Boxing, the NAIA, these different groups that were not influenced by recent politics, but came to these decisions after studies, after lengthy examination, and reached the same decision that Idaho has. Justice Gorsuch, in your colloquy with Respondents' Counsel, she agreed with this, that this is not the same as the discrimination that has been faced on the basis of race or on the basis of sex in this country. We agree it's not close to the discrimination that people have faced on the basis of race or sex in this country. That said, the court does not need to reach that answer here, because if there is no transgender status classification in Skermeti, there certainly cannot be one in this case. In fact, as our briefs argue, the court can and should avoid all of these questions by applying rational basis review. Bottom line, sports are assigned by sex because sex is what matters in sports. It is the fairest and the safest and the most administrable way to assign sports teams. It's been widely accepted for many decades because it's necessary for fair competition, because where sports are concerned, men and women are obviously not the same. If Idaho can't enforce a sex-based line here in sports where nobody disputes that biological differences matter, then no line based on biological sex can survive constitutional scrutiny. The court should uphold the Fairness in Women's Sports Act and reverse.
Thank you, counsel. The case is submitted.
Ladies and gentlemen, you are staying for the second case. Please remain in your seat.
All right, guys, I kind of need to go run an errand, but I'm going to leave this live.
Argument next in case 2443, West Virginia versus BPJ. Mr. Williams?
Mr. Chief Justice, and may it please.
Also, just, wait, what was that? Hang on. Why are you freezing on me? I did just make $577 on a stock trade. So, already a good day. Already a good day. I've got to go. I'll be back later. I think I'm just going to leave this up, though, and let the oral argument stand. Why not, right? Why not let hungers hung?
It's done, confirm as much. Respondent says that West Virginia schools can no longer designate teams by looking at biological sex.
Should I do that?
Instead, schools must place students on sports teams based on their self-identified gender. But that idea turns Title IX, a law Congress passed to protect educational opportunities for girls, into a law that actually denies those opportunities for girls. The court should not embrace that backwards logic. Aside from its problems with Title IX, the decision below constitutionalizes one side's view of a hotly disputed issue. But West Virginia's law does not offend the Equal Protection Clause either. The West Virginia legislature reasonably and rationally defined sex based on biology and acknowledged the physical differences that biology creates. Given those differences, the law satisfies rational basis review. And the state's law satisfies even intermediate scrutiny because it is substantially related to the important governmental interest in ensuring fairness and safety in girls' sports. Respondent attacks the law by searching for a transgender classification that simply isn't there. The law is indifferent to gender identity because sports are indifferent to gender identity. Ultimately, West Virginia's law, like the laws of at least 26 other states, simply preserves the enduring structure on which girls' sports depends. It should be upheld. I welcome the court's questions.
What's your view of what Title IX, how it defined the separated sexes, male and female?
So under Title IX, Your Honor, we would look to the ordinary understanding of sex at the time that Title IX was passed, 1972, and I think also relevant would be 1974 when the Javits Amendment was passed. And at that time, the ordinary understanding of sex was biological sex, consistent with the understanding of sex reflected in West Virginia's statute. I think that's also consistent, frankly, with this court's own understanding of sex and some of its own cases like Frontiera, where it likewise focused on things like reproductive function.
Well, with that definition, how would you square this challenge with the continued existence of Title IX?
So I think this challenge fails under Title IX, and in fact, it amounts to a backdoor attack on Title IX, in the sense that Title IX itself contemplates sex distinctions, and express regulations specifically applying to the context of athletics expressly contemplate the distinctions between sex of male and female sports teams.
So in interpreting this definition, would it make a difference, or does it make a difference that this is a spending clause statute?
I think it absolutely does, Your Honor. Obviously, in the spending clause context, as this court has somewhat recently reminded lower courts, it's important for Congress to speak with an even clearer voice because of the contractual nature of the conditions that are imposed. States like West Virginia have to understand exactly the obligations that they're assuming in the context of a spending clause analysis. And so it amounts to effectively a canon of construction that requires that clearer statement in order for the condition to attach.
I would have thought that's an interesting argument, that this is spending clause legislation in Title IX, and Congress has to speak with a particularly clear voice, and whatever it's said here isn't clear enough. You didn't raise that argument. And there's an argument from your friend on the other side that you waived the argument, or forfeited it at least.
Right.
And it sure isn't the lead argument in your brief. Help me out. Why?
So we, of course, start with the plain text of the statute, Your Honor, as this court has told us to do several times.
Yeah, well, I might start with the constitutional authority under which that statute was adopted, counsel.
I think that's equally compelling authority for our understanding of the
equally compelling, Constitution equal?
Perhaps greater compelling
I would have
authority.
thought, yeah.
All right, Huggers, I'm going to step away for like 45 minutes, but I'm going to leave this up.
Your Honor might know from past cases, but
this just
in the spending clause context, I think it is in fact the case that your court has repeatedly stressed that Congress has to speak with that.
I know what we've
There's
said.
a chance this
I'm
ends.
worrying about what you didn't say.
And it's just dead air here.
I think if you're looking at the way that West Virginia has characterized it, certainly we have made that argument and presented that argument to this court. I'd refer you to the topside brief. It's clear and centered under a clear heading. As I think what their suggestion is from the other side is that we didn't clearly enough raise that argument below. We would take issue with that characterization. There was obviously binding contrary authority in the Fourth Circuit. And so I think strategically we decided not to make that the front and center argument because we understood that was dead on arrival in that particular court. But that's not to say that we waived the issue by any means. It's a canon of construction that continues to assist this court in its application of the text of the statute.
But counsel, can I just ask you about this, though? Have we ever applied the spending clause's notice requirement outside of the damages context? Because here, we're not talking about a situation in which BPG is seeking damages, and I thought that was sort of a crux of the spending clause analysis.
I will concede, Your Honor, that many of the cases that talk about this rise in the context of, or maybe even all of the cases
Yes,
rise in the context. I'll concede as much, yes, Your Honor, but I don't think the court has ever suggested that the specific request for damages is the reason for its analysis, and I think that actually would be inconsistent.
But we would be having to address that, I guess, and extend it in this context if we were to take a spending clause tack.
I would respectfully disagree, Your Honor. I would say that just because the court hasn't done so before doesn't mean it's an extension per se. I think that what the court has said is that you view the language of these statutes as effectively contractual agreements. And I think that that same sort of contractual logic applies whether you're asking the state to pay out damages or whether you're asking it to take specific action under compulsion of that.
Who is the contract between here? And I thought the regulated party needs to know what it's agreeing to so it can consent, but here the regulated party is the schools, and it's the state that's coming in. So I'm just trying to understand how the spending clause analysis works in this context.
So I think the state is certainly one party that does receive federal educational funds, but it's also the many other petitioners that stand before you, including the county school board and the state school board, are also petitioners in this case. I think there would certainly be, if anybody, we're clearly bound by the conditions of Title IX.
So it would map on. I mean, I guess I'm worried that this might actually implicate the question that we didn't resolve in Moyle, and so we'd have to kind of figure that out, because it seems like it's a different set of facts than the typical spending clause application.
I think, if anything, Your Honor, this is maybe easier than your typical spending clause analysis, because you've got everybody from the state all the way down to the local county school board. Anybody and everybody who's involved in this case is a party to this action. In fact, you resolved a petition for cert from the Athletics Commission saying we're not actually a state actor, and the Fourth Circuit saw things quite differently. So I think there's really no concern in this case that you'd have an absent actor problem when it comes to the spending clause analysis. And ultimately, of course, if it's just a canon of construction, if you're looking for a clear statement, then I think it would apply regardless of the particular party who might be in front of you, because the statute applies across the board. You know, the regulated party is going to be affected regardless of whether they happen to be in front of you in the given case.
I quit my job and just trade
I
stuff.
presume that if it's statutory construction,
Then I
a
can
canon of
stream
statutory construction,
and hang out with
it's hard
you
to say you
fuckers.
can waive that.
It's very hard to say you can waive that, Your Honor. Yes.
I just wanted to ask
be
if,
back.
on your
Be right back.
understanding of Title IX, you could have separated by sex classrooms in biology or math based on some evidence that you have that say men are better at math and science. What are the limits to your Title IX theory?
So I think your instinct there in part arises from the fact that we're skeptical of any notion that there are inherent differences. So I want to kind of acknowledge the real reality of this.
Well, your whole position in this case depends on there being inherent differences, right?
It does, and I think that that's exactly why discrimination in the Title IX context, where it acknowledges merely inherent biological differences, that's not discrimination, that's a distinction. And I think that's consistent with this court's long-standing understanding of what discrimination means. It looks to differential treatment of similarly situated individuals. So even in a case like North Haven, you're talking about differential treatment of similarly situated individuals. So if we're talking about in an athletic context, you're not addressing similarly situated individuals. And I think, again, the Javits Amendment and the regulations that flowed from the Javits Amendment are a realistic reflection of those meaningful biological differences.
The Javits Amendment gives you a reason in the sports context maybe to do it. I'm just wondering whether, your friends on the other side have basically conceded that Title IX allows sex-separated sports teams. So I don't know that we need to really get into that. I'd be a little bit concerned about what the ramifications of that might be. And the Javits Amendment, in the context of sports, makes a difference anyway. But more broadly, I mean, if a state produced some studies saying, listen, women's presence in, calculus is holding men back because they're so much more capable and they can just move so much more quickly, seems to me like there'd be some risk on your understanding that that would be okay.
I think, again, realistically, Your Honor, that would almost certainly fail on the lack
Well, how about chess club?
A chess distinction, I think, again, might fail because there's an actual lack of evidence of meaningful physiological differences that are reflected in the existence of the express regulations in the athletics context.
I mean, I think a lot of people would say, if you look at the ranks of chess grandmasters, there are not a whole lot of women there. And, what does that mean? Well,
I think...
I think that there's a sort of intuitive... I think there are a lot of chess grandmasters who would tell you that women just, for whatever reason, they're not as good as this.
I think chess is an interestingly closer question. I've come to understand just recently, in fact, that there are sex distinctions
well,
in the elite.
You're fighting the hypothetical, and I guess the question really is, okay, Title IX says you can't discriminate on the basis of sex.
Yes, sure.
I understand what that means. I think I do, right? Can't treat men and women differently. Okay, all right, fine. But you're saying, but it matters whether they're similarly situated, and your friends in the government like that line too. Well, I got a lot of evidence that girls perform a lot better in high school than boys. Okay, there's a lot of scientific evidence, whatever, or let's just posit that, all right? Well, so I'm going to have a special remedial program for boys, and the women can't come. And because they're not similarly situated. Why on earth would Title IX care about that? It says you can't discriminate on the basis of sex in a program or activity of your educational institution.
So I think...
Why put that gloss on it?
And, Your Honor, I want to be clear. I think the task for the court today is somewhat easier in part because of the express regulations that they have actually not challenged and that do expressly contemplate exactly what West Virginia has done. So I think your hypothetical, yes, of course, is there, but I think the reality is that Congress and the agency have together kind of addressed this specific question in a way that makes this court's task much easier. But I think the problem maybe with
another answer, we don't need to rely on this similarly situated argument? Is that what you're trying to tell me, counsel?
I think you could also take that approach, yes, Your Honor. And I think the reality is that that hypothetical addresses a situation that's much closer to the sort of exclusion and the specific context that gave rise to Title IX in the first place. And so I think that the court would be much more legitimately concerned that that would detect the very problem that Congress is trying to head off in passing Title IX in the first place. But I think that really kind of puts the lie to the position that West Virginia is somehow discriminating because it's advancing the very same purpose that Congress itself was trying to advance in enacting Title IX in the first place. I mean, that's why West Virginia somewhat deliberately made its law mirror the exact same language from the express regulations themselves.
I'm afraid I've got one more question. I'm sorry. Please go ahead. No, you're...
I can do both.
No, you can't do both. That's not fair. That's not fair. I mean, even by our standards. You make the argument that on the basis of means solely because of. Solely. We have long said that because of means but for, not solely because of. The Rehab Act speaks of solely because of. It seems to me an awful big stretch, counsel, to say that on the basis of imports anything other than but-for causation. And, Comcast is against you there. And I just wonder, why you put your eggs in that basket?
So, 3 answers, Your Honor.
And by the way, isn't the distinction here solely because of sex anyway?
Well, let me take each of those in turn, or I'll try. I don't think that the case turns on the court accepting the idea that it's solely on the basis of sex. So I think you could stop.
That's a sufficient answer right there.
Fair enough.
Thank you. Your turn.
Thank you.
Can you explain the relevance and significance of the Javits Amendment to distinguishing sports from all these other hypotheticals?
So I think the relevance and significance is Your Honors are faced with a unique set of regulations in that Congress was directly, intimately involved in both the instigation of the regulation in 1974 and then sort of...
And in that law referred to the nature of particular sports, right?
It did. So what they said was, we want you, the agency, Hugh, to go ahead and implement Title IX writ large. And it called out one specific problem that I think arose on the floor about whether Title IX applies to intercollegiate athletics, in particular intercollegiate athletics. And I would say...
And that's been extended to high school by the regulations. But,
exactly.
But ruling for you on sports does not open the door, in my view, given the Javits Amendment, to the chess club necessarily. That could be separately analyzed, but it doesn't follow from a law that says sports.
That's exactly right, and that's exactly why we were trying to make your job easier in the sense that we took the language expressly from the regulations and mapped it over under our own statute. So there's really no debate. If it's outside the context of Title IX, it's outside the context of our statute. So at that point, the court's analysis is done. But I think when you have a regulatory scheme where Congress was specifically involved, in fact, undertook a review, then that's exactly the sort of regulation that even in a post-Loper Bright world continues to have importance because it's long-standing, continuous, contemporaneously issued, all those sorts of check boxes that this court, under a Skidmore framework, continues to place substantial weight on. So I think that makes the court's task relatively straightforward.
And what about Bostock?
No.
You want to deal with Bostock?
I think, so I guess it depends on the way in which you mean it. Does it deal in Bostock?
If an employer said we're going to fire all the transgender women,
right,
that'd be a violation. If a school says we're not going to allow the transgender women to play sports, you say that's not a violation. Both statutes use the term sex. Can you explain?
I think the reason why is, well, to be clear, our statute is very different from a specific choice to say a transgender person shall not participate because of their transgender status. And I think that really is what makes the difference between this case and Bostock, is Bostock is attacking status-based discrimination, and West Virginia would, I think, be in a much different position if we had just said transgender persons shall not compete. But that's not what West Virginia.
What if it said transgender women and girls shall not compete in women's and girls' sports?
I think, again, that's a much closer question. I think if we're talking about engaging with the actual status.
You think you could lose under Title IX with a statute that said that?
I think Bostock, is, now I understand Your Honor's question. I think Bostock raises an interesting question as to whether that reference to transgender status would in turn implicate the sex status that Title IX is meant to address. But ultimately, I think the court doesn't need to address that because you can stop at the first step, right? You don't have an actual transgender exclusion that would give rise to that kind of linkage of analysis.
Thank you, counsel. In terms of Bostock, I understand that to say that discrimination on the basis of transgender status is discrimination on the basis of sex. But the question here is whether or not a sex-based classification is necessarily a transgender classification. And I wonder if that is consistent with your understanding.
It's entirely consistent. I would say on the equal protection side in particular, and also in the Title IX context, I think for some of the reasons I just discussed with Justice Kavanaugh, I think the court can stop and say that a sex definition and a reference to biological sex is not the same as a transgender classification. And I think even if we engage in the sort of but-for causation analysis, I think it's as simple as saying, does the result change if you change the gender identity of the individual involved? And the reality is, if you apply the West Virginia statute to someone identifying as a biological boy identifying as a boy, applies in the very same way as a biological boy identifying as a girl.
Justice Thomas? Justice Alito? Justice Sotomayor?
I find it strange that the district court and the court below did find a Title IX violation, but not an equal protection violation, and remanded for the equal protection violation. I'm not sure how it could do that, because it would seem to me that if the evidence is not sufficient to justify finding an equal protection violation, it's not sufficient to find a Title IX violation. Is that correct? At least on the record as it exists now.
Right, and so to be clear, the district court actually ruled for West Virginia on both Title IX and so the Fourth Circuit said you lose on Title IX and we're not sure about equal protection.
But let's assume the Fourth Circuit is right.
Right. Well, so in answer to your question, I think that doesn't make sense. And I think the reason why it doesn't make sense is because the Fourth Circuit effectively stripped out what they said is Title IX doesn't leave room for any kind of justification or any kind of analysis of what the reasons might have been for the state's action. And I think respectfully, particularly when you look at the regulations themselves, that actually does contemplate exactly that sort of analysis.
I agree with you on the regulations.
Right.
And so could you not have a Title IX violation but still have, let's assume, and I know you're going to fight the factual premise.
I'll try to embrace it, Your Honor.
All right, embrace it. All the scientific evidence showed that there's no difference between cisgender girls and trans girls. I know there's a fight about it.
It hurts.
I know it hurts. But assume it. Could you not still have violated? Could we hold that as the regulation stands, the regulation would permit you to discriminate, but the equal protection clause would not.
So let me try to get my head in the framework of assuming. I think the regulation would still allow us, under its express terms,
I'm assuming,
right.
Yes.
And so you're asking, even assuming our compliance with the regulation, could we still have a potential equal protection problem?
Yes.
In that world, I think we would still be fine under the equal protection analysis, frankly, for some of the reasons that you heard from the solicitor earlier today, where it's because even if you assume the heightened level of scrutiny, let's assume that we're in intermediate scrutiny world, it's still a reasonable fit. It's not a perfect fit.
Then we're back to that.
Exactly. And I know we've had a long colloquy about that today, but ultimately I think that's what
I just destroyed that by saying that the science has said there's no difference. Well, and we know that's not true. But assuming the science said there was no difference,
right?
How could you ever say it's reasonable?
So I'm assuming a world in which there's no difference between. So you're saying testosterone suppressed individuals? Is that?
No,
or you're saying all men and women, full stop?
Right.
Oh, okay. Maybe I apologize for misunderstanding the hypo. If we're assuming a world in which there's really no biological difference, full stop, as to men and women, full stop, then I think, right, the legitimate governmental interest falls away. I agree with you.
Justice Kagan? Disagree? Justice Kavanaugh?
There are, as we've discussed, a bunch of states that allow biological males who identify as female, transgender women and girls to play women and girls sports. We were talking about that with the Solicitor General earlier. On your theory of Title IX,
right,
are those states violating Title IX rights of the biological females?
I think it's a much closer question under Title IX than it is under equal protection. And I think the reason being is that the regulations specifically say
what do you think the answer is under equal protection? I might as well ask that.
So under equal protection, I think we agree with our friends in Idaho that there's enough room for California to make a different determination.
Okay.
I think under Title IX, the reason why it's a closer question is because of the existence of the regs. And the regs start by saying you start with co-ed teams, and then you can move down to sex-separated teams in the context of contact and competitive skill. And it really contemplates a real, genuine sex distinction in that move down B provision. Mm-hmm. And then, of course, it pivots. It also has the catch-all where it says, but actually, in the contact sports, you can't even you can't move back in the co-ed world. So I think if a state is moving away from a genuine sex distinction as the regulator contemplated and as Congress ultimately contemplated, then maybe they're kind of, if you think of B as a safe harbor in a sense, they're outside the scope of that safe harbor, and now they're running into the problem in A. So I don't think the court needs to get into any of that.
Right, I agree. I'm just trying to know what's coming.
But I think that it's a closer question at least than the equal.
Because your theory is that sex is biological sex in Title IX, or is that not your theory?
No, that is, and it's not our theory, Your Honor. It's just it's the ordinary understanding of what sex meant, both in 72 and 74 when the regulations were themselves implemented. So I think we're just trying to be consistent with that.
Thank you.
Thank you.
Justice Barrett. Justice Jackson?
So I guess I'm trying to puzzle through whether or not there is some independent form of discrimination against transgender women that is distinct from the sex separation that Title IX allows. So I appreciate that your argument is that because the regulations permit sex separation and that hasn't been challenged, that should be the end of this inquiry, basically. And I think you get there because you say you're sort of picking up on this idea that maybe this is just about a definition of who is a male or a woman. Is that right?
I think to some degree, but it's also, Your Honor, it's just because we're indifferent to a person's gender identity in applying the law.
But the law actually operates differently, I think, for cisgender women and transgender women. That is, with respect to their desire to play on a team that matches their gender identity, cisgender women can do it, transgender women cannot. And so we do appreciate a distinction, I think, that is being drawn on the basis of your gender status, gender identity status, trans or cis, right?
So And I want to make sure I understand if we're operating in Title IX world or equal protection world, because I think it might make a difference to the answer. But
Okay. Let's start with Title IX.
So Title IX, I think the question of, I look at this statute and see a distinction between boy and girl indifferent to gender identity. And I think that...
Right, but I'm testing that proposition, right? You see that distinction, and I see it too on the separation of teams level at the beginning.
Right, and I think what I'm hearing is that distinction arises from a difference in effect, and I don't see a disparate impact analysis that's sort of hidden away in Title IX.
But why is that a difference in effect? So it's like a second order discrimination, right? The first order is separating male from female.
Right.
The second order is separating transgender women from cisgender women, right?
Respectfully, I would disagree.
No.
The reason why is just because I think anytime you have a classification, you could divide it into subclassifications, and I don't think that then becomes, like, the law in the same way applies to brown-haired biological girls and blonde-headed biological girls.
No, I understand, but I don't think you can get...
based on hair color.
I'm not sure, and maybe this is switching to the equal protection. I don't think you can get out of the implications of making a classification by setting it up as a definition. You know, as a subclass, and so we've already okayed the classification because it's really all about classification. You can't distinguish in that way, right?
Well, I think what the court said on the equal protection side is you look at the facial classification, and I think here it's effectively unconceded that the facial classification is between boy and girl. And I think at that point, if maybe you have a situation where you think that the classification is somehow a proxy for some sort of secret secondary classification, but I don't.
No, but the definition implicates another division. So here's an example. So suppose that we have Title IX exempting, and I think it does this, certain religious institutions from its requirements. And let's say Title IX then went on to define, this is in my hypothetical, religious institutions to include only those institutions that proselytize. I mean, is that a classification problem or a definition problem? I would say it would be a classification problem, and you'd still have to apply all of the heightened scrutiny just because, you know, they're defining religious institutions in a certain way. Similarly here, you have the overarching classification, you know, everybody has to be, play on the team that is the same as their sex at birth. But then you have a gender identity definition that is operating within that, meaning a distinction, meaning that for cisgender girls, they can play consistent with their gender identity. For transgender girls, they can't.
So I think that, okay, so as to the part about your ability to pass over from boy to girl,
yes,
you can go from one way but not the other. I want to be clear that BPJ is not challenging that specific classification. I think that's important to start with. But I think, if anything, that's useful evidence as to the lack of a transgender-based discrimination, because if the legislature were just sort of unsettled by the notion of transgender athletes, I think the answer would have been to then bar them from passing over in any way consistent with their gender.
I appreciate that. I guess I was getting at the what I understood the Chief Justice to be trying to discuss, which was this notion that this is really just about the definition of who we accept that you can separate boys and girls, and we are now looking at the definition of a girl, and we're saying only people who were girl assigned at birth qualify. And
there is authority cited in our brief. This court, I don't think, has ever phrased it quite as in the way of this definitional framing that we're talking about right now, but certainly cases like Jana Rock in the Second Circuit do approach it from this sort of definitional framing, and they say that if you effectively concede that there's an initial ability to draw a classification, then that suffices to satisfy the intermediate scrutiny question. But then past that, the definitional question is evaluated through rational basis review, and that's Jana Rock. I recognize this court has never gone as far as that, but I don't think the court needs to go as far as that, because, again, I think the way that you would do the analysis is to start by looking to the face of the statute, and if the face of the statute is engaged in a conceded boy-girl sex classification is conceded to be legitimate, then at that point, you kind of know which world you're operating in.
Thank you.
Thank you.
Thank you, counsel. Mr. Mupan?
Mr. Chief Justice, and may it please the court. So there have been a lot of different arguments made this morning, and so I think it might be helpful to just focus on what I think are the easiest way to resolve both of the claims in this case. On the equal protection claim, it's the arguments we discussed this morning about intermediate scrutiny doesn't work on this as-applied basis. So let me focus for the Title IX claim. I think the simplest way to resolve the Title IX claim in this case is as follows. The regs expressly authorize sex-separated teams. The other side isn't challenging those regs. When those regs use the word sex, they obviously use the word sex to mean biological sex in the reproductive biology sense. That's the ordinary meaning of the term in 1972 and 1974. As a result, whether or not they are right that taking testosterone suppression eliminates any physical advantage doesn't matter, because the regs define separation based on sex, based on biology, not based on circulating testosterone levels. So the difference that their claim that they've eliminated the difference just doesn't matter under the language of the regs, and that's enough to resolve the case.
So your argument, as I understand it, is that they're not similarly situated.
So that's an additional argument you could make, is to say that even if you just focus on the language of the statute says discriminate on the basis of sex. Discrimination, as this court has repeatedly recognized, including in Bostock, means treating one person worse than someone who is similarly situated. And yes, we don't think a man taking performance-altering drugs is similarly situated to a woman, but you don't even have to reach that question, because under the regs, the question is, the regs say you could separate based on sex. Everyone agrees that sex in those regs means biological sex. Therefore, the circulating testosterone levels are just legally irrelevant under the regs.
So why do you say you can separate the sexes? Why are you now taking the position in other cases that if states choose not to separate the sexes in the way you want, that they're violating Title IX?
Well, so again, we think that's a separate question, and you should leave it separate. But the argument we're making in those cases is the statute and the regs allow separation based on sex because of the biological differences between men and women. If you purport to separate based on biological sex, but then you allow some biological males to play on the female team, you've undermined the justification for separating in the first place. Because normally you can't separate. If you take, for example, world history class, you can't have world history class for men and women. That's generally prohibited by the statute. The reason you could separate for sex, for sports, is the biological difference. And if you then undermine that, you've undermined the justification for separation.
So we're now back always to the science. Is there really a difference? And a difference for this kind of person? If it's not clear the way you want it to be in terms of separating the sexes, I'm wondering why it's clear for your attempt to force those states who are choosing not to do this. You're now saying you must.
Again, that question is not presented in this case, and for this case, the factual dispute is irrelevant.
Mr. Mupan, do you think that the spending clause should inform our analysis here?
I don't think this court should invoke the spending clause in this case.
Why not?
For two reasons. One, we think that the statute and the regs clearly do not permit the claim.
I understand that.
And then the second is how the spending clause applies in the context of Title IX is, I think, a little more complicated than my friend suggested. It's not a clear statement requirement. I think if you look at some of these clear notice cases like Jackson and Geyser, I don't think you would say that those statutes had a clear statement.
It's a clear notice requirement.
Right, but how that applies is a little tricky, and I think in a case...
Why? I mean, your argument is that in 1974 and 1960, sex meant biology, and that it's not clearly, there's not clear notice otherwise. Why isn't that the end of it?
Again, so I think the end of it is the statute clearly doesn't permit this claim. I'm just saying that I would be cautious about speaking about how the clear notice requirement applies, because it is not a clear statement requirement.
I understand that. You're not answering my question with respect.
So I guess
if it's a clear notice requirement at minimum and a voluntary agreement, and sex at the time of the statute meant, as Bostock said, there's a good argument it's biology. And why wouldn't West Virginia be within its rights to say we didn't have clear notice otherwise?
the scope of the clear notice requirement is a tricky question. If you look at this court's cases, I suspect...
What's tricky about that?
I suspect Your Honor would think a lot of the cases where this court has found Title IX to apply, you would think there's not clear notice.
All right.
And so I think it's a tricky issue, and I think it's a case that should be briefed, and I don't think it's an issue you need to solve in this case.
And then on the statute itself, it speaks of discrimination in program or activity, and in Davis we explained that that requires kind of a look at the whole of the institution, because the definition of program activity is the whole institution. And so that's less individual focused, it seems to me. Thoughts?
Well, I think that's true for the funding, but I don't think that's true in terms of how the discrimination provision works. If you discriminate or exclude in one part of the school, I don't think you could justify that by saying, well, all the rest of the school, we treat everyone fairly. I think those cases you're talking about, as long as you're receiving funding somewhere, the whole school's activities are covered.
Okay. And so it really boils down to the living accommodations provision, which Congress anticipated there would be sex-separated living accommodations being permissible, the Javits Amendment, and then the regulations that are long-standing and then therefore are entitled to some serious consideration.
Well, no. So, Your Honor asked why we run the similarly situated argument. Take, for example...
Don't bring that back up.
Well, locker rooms and showers aren't covered by any of the things you just identified. Not the living facilities provision, not the Javits Amendment. None of those things covered locker rooms and showers. So unless you use a similarly situated requirement, you would have to say that Title IX bans single-sex locker rooms and showers.
Okay, all right. If that's your view, then let's talk about the similarly situated. I guess I have to. What about the hypothetical I posed earlier that when it comes to high school performance, girls are sure a lot better than boys, and so we're only going to have remedial classes for boys and girls aren't free to attend.
So I don't think those differences are based on inherent biological differences.
Well, let's say I've got really good science. I mean, it's all about the science, right? I got the science. You're fighting the hypothetical.
I'm not fighting the hypothetical, Your Honor. I think what I would say, Your Honor, is that this court has held in cases like VMI that, in general, classification based on sex is impermissible because, in general, men and women are similarly situated. Where that's not true is for the sorts of real, enduring, obvious differences that this court talked about in cases like VMI, the differences in reproductive biology. I don't think the sort of pseudoscience you're suggesting has been baked.
Well, it's not pseudo. It's good science.
It's not pseudoscience to say boys' brain development happens at a different stage than girls' does.
Well, with all respect, I don't think there's any science anywhere that has suggested that these sort of intellectual differences are traceable to biological differences. And I don't think the statute should be read to
With respect, I don't think you're a PhD in this stuff, and neither, I know I'm not, but I'm asking to deal with a hypothetical.
And so I guess what I would say about that, Your Honor, is...
I mean, the statute says no discrimination on the basis of sex. Right. And you're saying, it's okay when they're not similarly situated. And I'm giving you're worried about locker rooms. Right. Great, I appreciate that. But I'm worried about that math remedial class or the chess club or whatever.
Right. And so let me put it this way. The general rule is you have to treat men and women the same. And
I would have thought that's what the statute said.
And I think you have to be very careful about recognizing an exception. And so when you recognize an exception for what's similarly situated, I think you should tether it to the sorts of long recognized differences that would have been recognized at the time the statute was enacted. At the time the statute was enacted, no one would have doubted that it said it didn't require...
Oh, I think at the time the statute was enacted, 1964, there are a lot of people who thought boys are better at certain things than girls at others that we don't believe anymore.
Not based on inherent biological difference.
I think that maybe in 1964 they did.
And if they did, they didn't have any basis for it. Whereas for...
And I'm giving you a hypothetical where I have the science to prove it. And you're saying it's still not good enough.
I guess if you're asking me a hypothetical where the science existed in 1972 and everyone agreed with it, then it might be a different inquiry. That really is a hypothetical because there wasn't...
Do we have to, I think these are very, very hard questions. I started with the math question before. But do we have to, because of the Javits Amendment, because the other side has conceded that Title IX permits sex-separated sports, can we avoid your whole similarly situated argument that you run? Because I don't really like it that much either.
Absolutely. That's why when I stood up here, the first thing I said was the easiest way out of this case on this claim is to say that the regs permit sex separation. They don't dispute that.
Save locker rooms and all that.
Right. The only reason I went into it is I was nervous that any sort of suggestion that there isn't a similarly situated requirement could lead to results that I don't think the court would actually stand up to, like locker rooms and showers. And so I think I have no problem if the court doesn't take a position on it one way.
Okay, and I'll say, I said I don't like the argument. At first blush, I don't like it. I'm not trying to prejudice anyone making that argument later, but I think it opens a huge can of worms that maybe we don't need to get into here, because the Javits Amendment and the concession.
That's right. As long as you don't cut it off the other way, I think that's perfectly fine.
Thank you, counsel. Justice Thomas? Justice Lee? Justice Sotomayor? Justice Kagan?
Mr. Mupon, you talked about you are litigating this case the opposite way among states that do not prohibit trans women and girls from participating in sports teams. Is that correct?
Yes.
So, and you said, and I appreciate this, that we should not address that question. Are there arguments that that do suggest what the answer is on that question that we should be careful about? Or do you think that they're really self-contained boxes?
I think they're generally distinct, and what I could confidently say is the argument that I identified at the outset and with Justice Barrett just now, if you just say that the regs mean sex doesn't mean circulating testosterone, and therefore you're not required to allow boys to play on girls' team regardless of their circulating testosterone level, that argument would not influence the outcome of those other cases one way or the other.
Are there any arguments that would influence the outcome one way or the other?
I don't think so. Maybe if you engage in discussion about what the regs meant with respect to things like equal opportunity, that might be the sort of issue where it might have implications for the other case.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
I just want to be crystal clear about that. If we say sex in Title IX is biological sex, and then we get to the next case, the California case or whatever it is, how would California still prevail if we've said that here?
I think the argument the other side would make would be that the regs don't prohibit them from accommodating transgender individuals. Even though the regs permit separation based on sex, they also don't forbid accommodation of transgender individuals. It's the argument they would make. And they would say it doesn't matter that you're allowing some boys who have a biological advantage to play on the girls' team.
What's the argument you're currently making in opposition to that?
That the justification for separating on the basis of sex is the biological difference, and so you're undermining the justification for the separation.
Right, and so we start with the separation. I think what you're saying is once you separate boys and girls teams, which everyone does, and it may be even required in my view, to have equal girls teams, then California really doesn't have an argument if we say that sex in Title IX means biological sex, which may be okay. I just want to make sure I know what we're doing.
Look, Your Honor, obviously we don't think they can argue that, but I'm confident that California would stand up here and say that even if you ruled the way I just urged, they should be able to argue the opposite by saying essentially that they're allowed to accommodate on the basis of gender identity, even though the regs mean sex and sex means biological sex. That's the argument they would make. Whether that argument's right or wrong is for another case, but I don't think if you adopt the argument I'm making here today, their hands are going to be tied.
Okay, and then on this premise that has been conceded, I just want to make sure I understand your view. My understanding is that it's sex-separated sports teams, so long as they're equal opportunity for girls and boys, are perfectly constitutionally permissible. Is that not your understanding?
Yes. Per the arguments in both cases.
I mean, it's conceded, but it's conceded because it's obvious.
Right, because there are obvious biological differences between men and women, and that's why.
Well, the why people may debate, but it's obvious, it's conceded, and so too Title IX, because of the Javits Amendment, at least, even if not Title IX originally.
Well, I would say even without the Javits Amendment, because importantly, the Javits Amendment is only intercollegiate. So.
And it's been interpreted in the regs, so to go to high school and no one's ever challenged that part. That's the part, okay.
Right.
But that also, sex-separated sports teams are perfectly permissible under Title IX, at least with the Javits Amendment and probably without, correct?
That's right.
And that's conceded, but that's, it's conceded again because everyone accepts that and has accepted that for a long time, so long as the opportunities for boys and girls, men and women are equal.
That's right. And I think what the other side in this case is trying to do is say, yeah, that's fine, but they're being excluded. And the problem with that is they're not being excluded from participating on the boys' team. They're choosing not to participate on the boys' team. Now, for understandable reasons, given their gender identity. But the state is not excluding them from the boys' team. And Justice Sotomayor, this explains the confusion in the Fourth Circuit's opinion, because I agree with you. It is very strange that the Fourth Circuit
Okay, we got to go back. Sorry. You can, well, finish that up. Sorry.
The reason why the Fourth Circuit found that there was a viable Title IX claim, even though they said that there was a factual dispute, is because they bought into this notion that because the transgender boy doesn't want to play on the girls' team, doesn't want to play on the boys' team and can't play on the girls' team, they're excluded. That's true even if they have a physical advantage. And so the court said, we don't care about the physical advantage, it's still a Title IX violation. And that's clearly wrong. That's a misinterpretation of the statute. And the error in it is that they're not being excluded from the boys' team, they're choosing not to participate on the boys' team.
Sorry, one more. Bostock does not control here because, fill in the blank.
Because the law doesn't classify on the basis of transgender status, it classifies on the basis of sex, biological sex. Just like in Scrimetti, the law there classified on the basis of age and medical treatment. Here, the law classifies on the basis of biological sex. The person's gender identity is wholly irrelevant to how the law applies.
Thank you.
Justice Barrett? Justice Jackson?
But they are being prevented from playing on the team that matches their gender identity, correct?
That's the effect. So let me use your example from earlier. You said there's a cisgender woman, she could play on the team she wants.
Right.
There's a boy who identifies as a girl, he can't play on the team he wants. Take that same boy and switch his gender identity, but say he still wanted to play on the girls' team. Say he was a very unathletic boy. He likewise couldn't play on the team. So it's not the gender identity that's keeping him off the girls' team, it's his biological sex. His gender identity is wholly irrelevant to it. Now, I agree with you, there's a very significant disparate impact on transgender individuals by this law, because they're the boys who are most likely to want to play on.
Have we said that Title IX never covers that kind of disparate impact in terms of its discriminatory effect?
Well, it certainly doesn't cover disparate. First of all, I don't think Title IX covers disparate impact, period, because it uses.
But in terms of its discriminatory effect, I'm just trying to understand it. Is there something to this notion that differential treatment in effect in this way could be something that Title IX cares about?
I don't think Title IX covers disparate impact even on the basis of sex, and it certainly doesn't cover disparate impact on the basis of gender identity.
Okay.
Thank you, counsel. Mr. Block?
Mr. Chief Justice, and may it please the court, BPJ signed up for school sports because she was an 11-year-old girl starting a new middle school who wanted to meet people, make new friends, and be part of a team. West Virginia argues that to protect these opportunities for cisgender girls, it has to deny them to BPJ. But Title IX and the Equal Protection Clause protect everyone. And if the evidence shows there are no relevant physiological differences between BPJ and other girls, then there's no basis to exclude her. In thinking through the Title IX claim in particular, it's important to distinguish.
What did I miss? Matthew, how did things go? I put Matthew in charge. Matthew, who do I need to ban? I'm going to give Matthew one ban. You don't have to use it today. Since Matthew was in charge, he gets to ban one person from the chat. Anytime from now into the future.
Which takes a wrecking ball to the text of Title IX and the structure of this court's anti-discrimination precedents. It would dilute Title IX's protections for everyone, not just transgender students, and not just in the context of sports. West Virginia's law treats BPJ differently from other girls on the basis of sex, and it treats her worse in a way that harms her. Outside the context of athletics, that's all BPJ would need to establish a Title IX violation.
Sports.
But the Javits Amendment provides extra breathing room for reasonable regulations that take into account sex-based differences in athletics to provide equal athletic opportunity for everyone. West Virginia's exclusion of BPJ does not fall within that framework. Unlike the exclusion of a
where's
cisgender
Mercado
boy,
going?
excluding BPJ doesn't advance any interest in ensuring overall fairness and safety. And unlike the case of a cisgender boy, excluding BPJ from the girls' teams excludes her from all athletic.
Jeef, you missed Jumanji Brown Jackson proving why she has no business being on any court, much less SCOTUS. Her being on SCOTUS it's one of those things that I just have to not think about because there's nothing I can do about it, and it's infuriating. Metal Nick, I think I'm still owed being able to ban someone from a competition many years ago. You are, Metal Nick. You are still owed that. Once again, it's good forever. If someone pisses you off in chat, you get to ban them, Metal Nick. I remember that. DJ Lunchbox, ban Austin. If you want to ban me, you can, and I'll just never stream again. That's true.
Disparate treatment on the basis of sex. So I think the claim is the discrimination, and it's perfectly possible to.
So doesn't that suggest that you're a subcategory of the sex of the relevant class of female athletes? Isn't that your point?
Yes. Well, for the equal protection claim.
Well, but you're not. My point is that you're challenging a category that does not exist in the statute, but is dependent upon the existence of a category in the statute that you're not challenging. There's a 50% chance
of that happening anyway.
I wouldn't put it that way. I would put it the way as there's a classification that we think is valid as applied to most people, but is invalid as applied to a discrete subset of those people. But I don't think the success of that equal protection claim hinges as an a priori matter on the existence of girls' teams. There are lots of ways to remedy an equal protection violation.
But I think, given the way you phrased it, the question becomes a
Frank,
little different
what?
because
You thought someone banned Cal Ticket? So no. There was someone who won marbles one time, and they were able to ban Cal Ticket for like one day. I never wanted to ban Cal Ticket. Cal Ticket was awesome, man. He was so entertaining. He was so much fun to fuck with. You know what's funny about Cal Ticket? He was such a liberal shithead. But he was banned from all the liberal streams too because he was such a liberal shithead. And he was like, Austin, you're the only streamer that hasn't banned me from chat. And I was like, dude, you should probably look into why that is. But I loved that guy. I know he pissed everyone off in chat, but I thought he was hilarious.
It's a claim saying it's as applied to them, it's okay, as applied to me, it's not.
Counsel, how do you get to a Title IX violation? I know exactly how you get to an equal protection violation, okay? If you accept that the regulation does, by its own terms, permit sex-based separate sports, does permit schools to do this, what in Title IX explicitly or even logically says that you have to give transgender
Thank you. I appreciate
girls the same opportunity? Because the regulation said, it's not just the statute, it's the regulation say, you can create separate sex teams.
No, thank you. I take the point. I think there's always been a tension between the underlying text of Title IX, which protects individuals, not groups, and the regulations, which are authorized by the Javits Amendment and have special leeway to make some group-based measurements. But if you look at the rationale for the regulations, Hugh, when it issued the regulations, said that we think that our group-based method, which otherwise would have been completely impermissible for Title IX, adequately protects the rights of individuals, because if boys and girls as groups are being given equal sets of overall opportunity, then every individual in the group also has a set of equal opportunity to choose from.
Yeah, I think that's the problem. And, you're absolutely right to worry about the wrecking ball, but I think we've kind of taken a wrecking ball to that. There's no solely in the statute, all right, and we're talking about individuals, but Javits changed Title IX, and it said, sports are different, and we've got these regulations that have been out there for 50 plus years, and normally Skidmore kind of comes in there, Forget about the spending clause, I guess, but maybe I'll ask you about that too. Well, why doesn't that make this case very different than Title VII?
Yeah, so I completely agree. The Javits Amendment is what makes this different from Title VII, and I'm very happy with however this decision comes out to have a decision that's focused specifically on the unique context of athletics as opposed to these broad arguments about Bostock applying to Title IX as a general matter. But I guess what I'd say is the regulations still require equal athletic opportunity. It's not a complete exception for sex-separated teams.
Yeah, but Javits says it can be reasonable.
Yes.
And do you dispute that the Hugh regulation that's been on the books for 50-plus years is reasonable?
I think it is absolutely reasonable as applied to cisgender students. I think that as applied to transgender students, instead of providing them equal overall opportunity, it's a complete exclusion from the program. And so that's our argument, that it's reasonable as applied in the context of cisgender people, but interpreting the regulations to authorize this sort of categorical exclusion that doesn't give BPJ an equal set of opportunities to choose from would be an unreasonable way to implement Title IX.
Okay, gotcha.
It's unreasonable as to all transgender students?
No, I think it's a combination. I think so. A reasonableness test, I think that requires some sort of ends means fit, and I think that exists when it comes to cisgender students. I think what makes BPJ's case differently from a cisgender student is two things. First, she doesn't have any of the physiological distinctions that justify the sex separation in the first place. And second of all, the harm to her is of a material different kind. It's one thing to say, we're not going to let boys play volleyball because they have all these other sports to choose from, or we're not going to let girls play football because they have all these other sports to choose from. It's another thing to say, you don't get any sports.
But in that argument, does it matter whether BPJ has a competitive advantage or not?
Yes, we think it does, and I appreciate the opportunity to clarify that we don't have any objection to vacating the grant of summary judgment in our favor. We did our best to defend the judgment below, but our argument before the Fourth Circuit for summary judgment was that there wasn't a genuine disputed fact about whether she had an advantage. The Fourth Circuit, sua sponte, granted summary judgment to us based on the theory that that fact wasn't material. That's never been our argument in this case.
So your argument depends on depends on her not having a competitive advantage because she's not been through male puberty.
And not just not been through male puberty, but also gone through a female hormonal puberty with all the physiological changes accompanying it.
But that the argument goes away if those facts go away.
Yes, absolutely. Which is at the beginning of the argument, Justice Kagan, you talked about this could be resolved based on a legal principle or based on the facts. And I really do want to make a pitch for the resolving it based on the facts because, look, if they're right about the facts, then we should lose. And the irony is that in order to win summary judgment in this posture, when there's a disputed question of fact below, is they can only win in this posture if we're right about the facts and there aren't any advantages. And I don't think there's any need at this juncture for this court to issue that broad a holding when, according to them, once the evidence comes in below, we're not going to get past summary judgment. I mean,
you're not suggesting that we decide the factual question.
No. I'm suggesting that the case be allowed to be decided on remand on the factual question, which I think, look, this is an important issue. It may affect the whole country, and the court wants to get it right. And I don't think the best way to get it right is to rely on, cherry-picked studies or assertions in amicus briefs. I think the way to get it right is to let all the facts they're trying to put in the record actually be put in the record. And then we'll have the facts in front of us, and maybe they'll make the issue go away. But I think that's unnecessary to intervene at this instance with a sweeping legal conclusion to something that might actually be a narrow factual dispute.
Counsel, can you explain whether or why your theory would allow a cisgender boy who just couldn't make the boys' team? I mean, he doesn't have an equal opportunity, he can't play, there's no team he can play on, and let's say that his athletic ability can be shown that he has no competitive advantage and he wants to be on the girls' team. Why can't he on your 3?
I appreciate the question. I think I just want to be clear about what we think the justification for the separate teams is. We don't think the boys' team is for better athletes and you have a backup team for athletes that aren't as good. I think the purpose of the teams is to control for the variable of sex-based advantages so that talented women athletes have all the same opportunities as talented male athletes. But also, untalented male athletes should be compared to untalented women athletes. So they're not being separated based on how good you are, right? The whole point is to allow female athletes to have all the same opportunities as men by controlling for the sex-based differential that comes through puberty. And so that's why I don't think that the claim is the same there. I think that's what's happened here is by virtue of her medical care, BPJ has already effectively controlled for those sex-based advantages. And so she is completely in the position that she would have been if her birth-assigned sex had been female. As opposed to a cisgender boy who's just not very good at sports, and if his birth-assigned sex were female, maybe he'd be even worse, I don't know. But again, the purpose is to control for the variable of sex to provide equality, not to have a good team and a team for people that can't cut it. Now, I'm happy to address—
Can I ask a question on the law, on Title IX? I mean, I hate that a kid who wants to play sports might not be able to play sports. Hate that. But it's kind of a zero-sum game for a lot of teams. And someone who tries out and makes it, who is a transgender girl, will bump from the starting lineup, from playing time, from the team, from the all-league, and those things matter to people big time, will bump someone else. And so one way to resolve it, as you say, is the facts, try to figure out, is there really a competitive advantage? I think we're going to get a lot of scientific uncertainty about that, a lot of debate about that, a lot of different district courts. The other way on the law, one way on the law is, okay, well, sex in Title IX and in Javits meant biological sex, and it's up to Congress to adjust that going forward if they want, given, as you say, and your co-counsel said earlier, you know, people are learning more about this, and maybe there really is no advantage. Well, if that's true, and some states are operating under that basis, that's the way to go. But for now, at least the law says biological sex. And I think we have to recognize on both sides the zero sum. It's not like, oh, just to add another person to the team. That's not how sports works. It's someone else is going to get disadvantaged. So I just want you to address that.
I'm happy to, and I guess I have 3 answers. I mean, the first is I completely understand that many parts of sports are zero sum, but this law isn't limited to zero-sum opportunities. So BPJ played on the cross-country team where there were no cuts. She came in near the back. It wasn't.
But I'm sorry to interrupt, but you wouldn't have a different rule if she was finishing in the top 5.
No, but it wasn't a zero-sum.
Or if they had cuts.
But what I'm saying is in
this particular case, but usually with teams, I don't mean to, just don't want to get out of that. Usually with teams, they're cuts.
Yes.
Those mean a lot to people. There's starting lineups. Those mean a lot to people. There's who gets a college recruit. That means a lot to people.
Yes. I just want to say that there still are some areas where there are win-win solutions. I think even being able to be on practices with a team consistent with your gender identity instead of your sex assigned at birth can be enormously important. So I think some scenarios are zero-sum, but not everything having to do with sports is. And I do think that one of the vices of this law is that it sweeps so broadly that even win-win solutions are taken off the table. In terms of aspects where it's zero-sum, no one likes to lose. No one likes to not make the team. And people often don't make the team. The cisgender girls don't make the team when competing against other cisgender girls all the time. And the question, I think, is whether it's an unfair advantage to not make the team because a transgender girl participated. And if there is no sex-based biological distinction there, then I think it's an unfortunate situation, but I think it's the unfortunate situation that comes with having a zero-sum game, not inherent unfairness. Then the third thing is, I think however the court resolves this case, I really urge the court not to do it based on a definition of sex argument. We are not disputing in this case that West Virginia can have its definition of sex. Our argument is it's using this definition to inflict discrimination and deny equal athletic opportunity, but we are not saying their definition of sex is wrong. However, I don't think it follows that Title IX created some national definition of sex that preempted states' ability to say, you know, actually, we are most concerned about discrimination that happens through gender roles. We think.
Can I ask you something? That's a very important point here, I think, for what happens in the future, what you just said. Do you think sex in Title IX can reasonably be interpreted to allow different states to take different understandings of that in their sports leagues?
I do, because I don't...
Why is that? That's real important, I think, going forward.
Right, because I don't think the purpose of Title IX is to have an accurate definition of sex. I think the purpose is to make sure that sex isn't being used to discriminate by denying opportunities. Just as I don't think we need to define race in order to enforce Title VI. So I think I wouldn't look to whether or not it's accurate to classify, BPJ as male or female. I think the question is she being denied an opportunity because of that classification? But obviously sex can mean more than just
So if we didn't want to prevent a different state from making a different choice from West Virginia, what should we not say, or what should we say to prevent that from happening?
Well, I wrote down the answer to that when you asked Mr. Mupin. I have two things. I wrote, don't give definition of sex, and I also said I wouldn't decide this by assuming that Title IX provides a right to single-sex teams. In the regulations, single-sex teams are optional, they're not mandatory, and in addition to that, we're talking about the regulations, but on the ground, the way this plays out in practice is you have a 1979 policy statement, a sub-regulatory document that has a complicated test for determining when a sex-separated team is or is not required. And so I think that both because I think saying there's a right to a sex-separated team would predetermine some of the questions in that other case. That's one reason why I don't think you should do that. But second, I think the more the court gets into questions that are handled in these complex regulatory documents, I think the more I'd be worried about this court accidentally saying something about how Title IX works that doesn't actually map on to how it is actually playing out on the ground.
Title IX prohibits discrimination on the basis of sex. It's a statutory term. It must mean something. You're arguing that here there's discrimination on the basis of sex. And how can we decide that question without knowing what sex means in Title IX? I mean, it could mean biological sex, it could mean gender identity, it could mean whatever a state wants to define it to mean, but it has to mean something. How can we decide that without knowing what the statutory term means?
Well, I think there are a whole range of sex-based characteristics that can give rise to discrimination. I think if someone said, I'm going to discriminate against anyone who acts in a feminine manner, like anyone with limp wrists, I don't care who they are, but I'm going to discriminate against them. I think that would be sex discrimination. It would be sort of gender presentation. But I wouldn't say that's not covered by Title IX. And so I'm not saying that biological differences aren't part of sex, but I'm saying that sex also has broader connotations, and there's no reason to keep that out of the statute. And I'm certainly not saying that sex means gender identity. I just want to be very clear about that. I don't think that, just as, I would say this, our argument is that there's a group of people who are assigned male at birth for whom being placed on the boys' team is harmful, right? We happen to have a word for those people. It is transgender girls. But I don't think that means that we're elevating gender identity to be the new definition of sex. Just as in Phillips versus Martin Marietta, there's a subset of women, who were harmed by the policy. Not all women, but there's a subset of women who had young children. And there's a name for them, it's mothers, but that doesn't mean that we're replacing the word sex with mothers. I think
How do you respond to or deal with the other side's characterization of that harm as just the disparate impact of this regulation? That really, it's not discrimination, I think they're saying, but it is just the downstream effect of the application of the classification that the Javits Amendment allows, and that's just the way it goes.
Yeah, so I guess I would say this. I think this court has dealt with the issue of things like constructive denials and constructive discharges in a variety of contexts, and under Title IX, an outright denial isn't required. Davis says a constructive denial it also counts. And whenever there's a question of constructive denials, the court applies a standard that's reasonable person in the plaintiff's position under all the circumstances. And they use that for constructive denials. You've used that for retaliation claims. And if you look at Burlington versus White, I think it's very on point here, because one of the points that Burlington versus White said is that there's some actions that aren't going to be harmful to most people, but they might be harmful to some people. So Burlington versus White used a mother with young children might find a change in her work schedule to be incredibly harmful, right? That doesn't mean that, we're arguing that, this is a disparate impact classification on people who have young children. It's a sex classification. The sex classification is just harming some people and not harming other people. So that's how we would view it. I think this is a facial sex classification any way you cut it. And
I'm sorry, you don't think we should have an operating definition of sex in Title IX? Now, I understand the idea that the question then becomes not whether or not there's discrimination on the basis of sex, but whether there's discrimination on the basis of whatever characteristic you think should be included in the definition of sex. Now, when it's used as a statutory term, I'm not sure you have that kind of flexibility. The question would be instead, what does Congress think the word means?
Well, Your Honor, I guess I'd say I think Congress prohibited discrimination based on sex. I'm sorry, go ahead. Yeah, and so I don't think that, just as I don't think Congress adopted a definition of race, in Title VI in order to prohibit discrimination on the basis of race. I think I'm not trying to police the accuracy of the terminology that's being used. All I'm saying is that what's being prohibited is using this classification to discriminate, not.
So well, but without really knowing what the distinction is.
Well, I don't think the examples I've given about sex-based characteristics fall outside the common understanding of things that are related to sex.
Well, related to sex. I guess what you're saying is that we do have to accept for your position that we're not dealing when Congress says sex, we're not dealing with biological sex, but we're dealing with other characteristics that people might associate with sex?
No. I think for this case, you can accept for the sake of this case that we're talking about what they've termed to be biological sex. I think that resolves this case. I was just talking about in addressing other potential cases.
So we don't have to say anything about the matter. You're willing for us to proceed on that assumption.
Exactly. Just like in Bostock, I think you can proceed for argument's sake without taking a definitive position here, because it might have downstream consequences in other cases that even the United States doesn't want the court to prejudge here. Now, I would like to say one quick thing on Justice Barrett's reference to separate classrooms. I mean, it is true, and the ACLU's litigated cases about theories that there's different brain sexes for women versus boys, and that's why you need separate classrooms. I think the instinct was completely correct that you can have a lot of scientific justifications for discrimination. That doesn't mean that the discrimination is allowed or immune from scrutiny. And in fact, some of the studies that are cited in the amicus brief say boys are naturally more aggressive, right, and favor competition more because that's in their DNA. So I do think even in these studies, the idea that you're completely, just basing it on pure biology and not on other generalizations doesn't quite hold up. I'd also, to the extent that we want to go back to Caban, I do want to just make a couple quick things clear. Caban was not a facial challenge. It wasn't. And neither was some of the First Amendment cases they were talking about weren't equal protection First Amendment cases. They were commercial speech cases. Michael M. also wasn't a facial challenge. He wasn't saying I should have an exception because a prepubertal girl was involved. He was saying the statute is overbroad because in theory it could apply to a prepubertal girl. So I do think that some of the characterization of the cases doesn't hold up to our reading of them.
So how does a Caban type as applied intermediate scrutiny analysis work in your view? It is an underdeveloped area of the law. Is it enough for one person to show that she bucks the trend or not?
Yeah, I don't think so. I think I agree with my co-counsel that I think we're talking about a discrete, definable group that will reliably not serve the government's interest. And I don't think Nguyen is a counterpoint to that, because the whole point in Nguyen was that men who were not similarly situated had an opportunity to demonstrate that. There are 3 very easy methods of transmitting citizenship. And Nguyen emphasized that in order to do it, those were minimal burdens. And that is the key fact in Nguyen that distinguishes it from this case. This is a categorical ban, and Nguyen and Caban and all the court's cases distinguish between categorical bans and more narrow procedural requirements that do treat men and women differently, but still provide the opportunity for demonstrating that you're not similarly situated.
I think a hard question that Ms. Hartnett got, maybe the hardest question on these lines, was if we recognize these sorts of as-applied challenges, doesn't that effectively turn intermediate scrutiny into strict scrutiny? Right. What would your answer be to that? Would it be any different, or
no,
do you want to elaborate?
I think the answer is it absolutely wouldn't. You still are only looking for a substantial relationship, which means that you can have these sorts of requirements where there are a lot of, under Caban and under Lair, there's still a lot of fathers that are out of luck, that they actually probably do have a good relationship with her kid, but they didn't fill out the right paperwork, they didn't do this, they didn't do that, and heightened scrutiny doesn't require that they be excused from those procedural burdens. So I do think that heightened scrutiny allows you to have procedural requirements that people have to go through, and those can be enforced. Strict scrutiny does not allow that, but that's different from saying that if the complete rationale for a classification just doesn't apply to you, that there's no equal protection claim you can bring. And some of it's complicated to talk about the difference between facial and as applied post-CASA, because I think a lot of the things that we called facial challenges now would be viewed as overbreadth challenges, right? Where someone is trying to say the law is so overbroad in general, it has to all be struck down. And we have that for First Amendment. I don't think we have that anymore for most equal protection claims. And so I think taking this facial as applied framework from before CASA, where we allowed these facial attacks on statutes, and then just transporting it into as applied cases post CASA doesn't necessarily work. I think some of the terminology might need to be rethought. And so again, that's another reason why there's not a lot of precedent in this area, as several of you all have acknowledged. And that's another reason why I don't think this should be the case that makes that precedent when it's unnecessary to do so.
Thank you, counsel. Justice Thomas? Justice Alito? Justice Sotomayor?
Would you address a little bit the quantum of certainty or uncertainty that would have to exist in the science? Your co-counsel, or the counsel in the other case, said that if it's 50%, the state loses. But I'm always hesitant about these percentage cases because it's never qualitative. It's never quantitative, it's qualitative. So what do you think the qualitative standard is?
Well, I mean, to be clear, I don't actually think there's uncertainty in the case of someone who's had puberty blockers and then gender-affirming hormones. Our position is there's zero uncertainty. It's actually clearly in our favor. So I But in general, I think it's hard to give, a quantitative answer to that. I think part of heightened scrutiny involves taking all of these factors into account. This court, has said on several occasions that heightened scrutiny can accommodate deference, and I honestly think it's a case-by-case decision that also looks at how harmful the classification is, how burdensome it is. I don't think you just look at the accuracy of the classification and add a number value for how certain we are that it's accurate. I think many other factors come into play.
Thank you. Justice Kagan? Yep. Justice Gorsuch? Justice Barrett? Justice Jackson? Thank you, counsel. Rebuttal, Mr. Williams?
I think you've now heard respondent abandon the Fourth Circuit's logic on Title IX, and I think in many ways that makes this court's task that much easier. Congress authorized regulations allowing sex-separated athletics. West Virginia's definition of sex tracks the ordinary meaning in 1972 and 1974 and the regulatory framework that Congress endorsed. I think, Mr. Chief Justice, your question really highlighted how BPJ's approach unmoors the statute and the regulation under Title IX on the basis of sex. BPJ's test, in turn, begins to look more towards other characteristics that aren't on the basis of biological sex, and I think that's not consistent with what we see there. I also think the answer to Justice Barrett's question reflected how, under BPJ's theory, this really isn't about competitive advantage, that really what this does turn on is gender identity, because BPJ continues to maintain that a cisgender boy who continues to not have those same biological advantages would nevertheless still be kept off of the girls' sports team. So if you endorse that philosophy, that would require the court to hold that long-standing Title IX athletic regulations are unlawful. It would eliminate sex-separated athletics entirely, and I think it would defeat Title IX's core purpose of ensuring equal athletic opportunity for both sexes. On the equal protection side of the House, the question is whether the classification is substantially related to an important governmental interest. And I think that BPJ ultimately wants to rewrite the classification to be something that it is not. Biological sex substantially relates to athletic performance. That's exactly why, in fact, Title IX regulations authorize sex-separated teams in the first place. Respondent's test effectively ratchets up the intermediate scrutiny standard into a perfect fit, best disposition case that this court has repeatedly said is not the standard under intermediate scrutiny cases. That is the standard for strict scrutiny cases. You have heard it several times today. Justice Sotomayor, you asked about deference. I think this court has also repeatedly recognized that in areas of evolving science and medicine, especially involving children, legislatures have the primary responsibility for weighing competing evidence and making the policy judgments. I think the court just recently said that in Scrimeti, but I certainly don't think that case stands alone in recognizing that, especially when you have competing balances of harms, Justice Kavanaugh, when you're weighing these sorts of zero-sum games, that's a choice, that's a policy judgment that ultimately rests in the hands of the legislature. In the end, this court has, quote, recognized physical differences between men and women. They are enduring, and inherent differences between men and women are cause for celebration. That is all that West Virginia's law does here. It should be upheld. Thank you.
Thank you, counsel. The case is submitted.
What? I have to actually do something as a streamer now? They ended the arguments? Fuck. Guys, I hate having to actually do something. What's going on here?
For my shoes.
I got some nice non-slip shoes, but there's not enough, especially when it's like very icy.
What should I change the title of the stream to now? I just typed in Hong stuff is happening, but I kind of hate it. It seems kind of gay. What should I change? Hey, chat, I'm going to let you guys decide what the title of the stream is. Quick, Austin, find us another stream. Eric, I know, man, I know. All of a sudden I have to do something? When I signed up to be a streamer, I thought I would never have to do stuff. I thought I could just sit here and make money. Like all the other streamers who seemed... How the fuck are streamers buying mansions? Like, bro, I'm a streamer. I don't have any mansions. Mids, get in here. Are these pro or anti-ice? Honestly, I don't know. Minnesota ice cold Hongs. I like that. Spicy ice balls isn't bad. A fake and gay stream. Frank, that's just, it's a little too on the nose. It's a little too true, Frank. Austin crashing out in 2026. The mid money is going to his head. I haven't seen you suck at Diablo once. Kind of your fault. That's true, Jay. That's true. I love you guys. You guys are... I hang out in a lot of places on the internet, and I see other chats. I do. And maybe I'm biased. Maybe I'm biased, but I don't think I am. The Austin Zone chat and the Austin Zone Discord are the funniest fucking places on the internet. Not only funniest, but just like the most real. And you guys discover shit before I see it anywhere else on the internet. We have the coolest fucking community here. We do. I don't know what else to say. You guys are fucking awesome. Dude, assuming you weren't just joking, the streamers who make it that big are doing it with endorsements and ad deals from mega corporations. Yeah, I mean, Chief, I was kind of just joking, but also not. And I know. I know.
I'm here just to bring you guys.
I know, like, I could try harder to, like, be a streamer and, like, push my shit out there, but it feels fake to me. Like, I can't do it. I can't do what I know I should do to, like, get my streams out there and, like, get more people here. I would have to be a fake motherfucker, and I can't do it. I just like to go live and fuck around on the internet and hang out with you douchebags. It's the chemicals in the water that makes Austin so what it is. No, you should only get news from approved media sources. You can't think for yourself. We lay low and hung when Austin appears. Right, Eric? Right?
Lori, how's it going?
Your mother
Welcome everybody who's just tuning in right now. We're right in front of the federal building here in Minneapolis, Minnesota area, where protesters have been out here for several days, maybe several weeks already, protesting anti-ICE. Thank you. Jamie, thank you. Has probably triple in size since I got here, guys.
That's the law that says you need to stop that. Because they hit the floor. Literally, I'm just there for a minute. Like, you can't like go around for one. Stop. Stop. I'm saying. be away at 3 miles per hour. But when they were out here yesterday, not one of them was saying anything back to them.
Don't be scared. But I had a bell that was ringing. Oh, they are. Fuck you! Fuck you! Fuck you! Get fucked in energy. After you're back with the white for me. The white for me goes fucking energy.
This looks like something you guys want to see. I'm disabled.
This is your duty!
God, I love watching ICE. Do you know how confusing this is for me? I've always been an anti-federal government. Like, I want the federal government to have less shit to do with our lives. I've always been kind of anti-federal government. I think local government is a better situation. 10th Amendment, it's why it's the 10th Amendment for a reason. But I find myself loving ICE so much I think because for once the federal government is actually doing its goddamn job, and I'm like, yes, this is what you're here for. Protect our borders. That's why we hired you. One time you're doing your job, and I love it. Still, fuck you, federal government. However, you're doing great right now.
Why don't you help someone? All you do is hurt. All you do is hurt. She's trying to drive down the fucking. Where is the law? Pull up the roof.
Nice. Good shit. Congratulations, federal government. You finally did your job one time.
Is there one down there? Is there a bag down there?
No.
Here you go. Take
all right, well, I can split it with him.
No. We're all good.
Door or something? Whatever the fuck you say, Mercado. Did you guys see Mercado got hit? He got hit the other day. I love the discourse. Fuck you! No, fuck you! So intelligent. I'm learning so much here. Alright, let me find Mercado getting hit.
I'll go to the other side, guys. That way we can catch the front of it when
Chief, you absolutely know who Mercado is. Funny that you actually don't know who he is, but you've been watching him on my stream for 6 years. He's such a little bitch. And the thing is he claims he's like non-biased, but he's such a lefty liberal fucking piece of shit. And yeah, oh shit, what's going on here? Hang on, guys, hang on.
Is Amanda riding with Adam?
Looks like she's in downtown. Adam's at Target on Lake.
Did Bavino go down to my town? Is he in Tampa? For that recruitment thing?
I'm not aware of if he left. I kind of would doubt it.
I know, me too.
Come on, chat, you guys are hitting. Pork rinds are awesome. They are. Oh yeah.
Man,
you have barbecue pork rinds?
These protesters sure gave up pretty quickly. If they actually cared, they'd be protesting.
Holly, Lakeland Riley's family has asked for you guys to stop politicizing her death. Stop.
You don't want to politicize this fuck ICE protest? Excuse me? Hey, no politics here. I'm just trying to be at a fuck ICE protest. I don't hear any politics, guys. What?
It is true. She's literally asked her family repeatedly not to politicize her death.
I don't know what.
It's weird when you guys just come up here and say you justify murder.
I was too embarrassed to hold them up.
Matthew, the president, you guys don't give a crap about felons. You don't. Hey Corey, it's Youre, Y-O-U-R-E.
There's this thing called ICE, it's like ISIS, and when they see the melanin, they tend to get excited. They want to put the brown folks up in the handcuffs and tell them they don't have permission to be on this land.
Yeah.
Daddy probably tell you that's some cracker shit. Who the fuck are these imposters? That's preposterous.
Woo!
Like you if you're pouring like a pot of piss.
Ew, don't call me Han, the fucking weirdo.
Obviously, man, this world is getting dangerous. Your own teacher might could be a little racist bitch. Just remember that we failed you and it ain't your fault. We'll sing the song when this shit comes on. Mother thoughts are sleepy, they are not good people. It ain't hard to see that they are sleeping. All my kids from the front to the back, so you gotta watch your back.
I don't think he's going to use the correct "your," but he's gone. I don't like it when white men or anyone calls me hon or sweetie or baby. That's my hard stop.
Never seen him in my town before. Hopping out the van, why am I surrounded for? Pretty rich trying to tell me I am illegal, and y'all asses looking like some European people. For the children that don't understand what I'm trying to say, it's a shitty ass place that they call the USA, where the propaganda telling you the land is free. Why they snatch away members of your family for some made up rules? It's insanity. They be committing crimes against their humanity. So all my homies up in kindergarten, raise your crayons. I got a great song that you can sing all day long. I like ice in my drink, and ice if it's cute, but motherfuck ice, bitch, you know how we do. Motherfuck ice, they are not good people. They want to see that they are straight.
Fuck you, Jim.
You gotta watch your back. Black. Look both ways when you cross the streets, cause you might get snatched by
Hey, we shouldn't have to leave because our countries are full of Nazis. No, I brought it in case
But there's mayo and mustard and cheese, I researched the heck out of it. There's no That's fair because they didn't get delivered. Papa John's.
JB, I was 17 when Obama was president.
Emily, I'm Denby.
And no, F you, I do not have teeth, I have dentures.
Oh, yes. So, I took down some of his information. He was saying, like, one thing that we would consider is organizing going into
Thank you very much. Thank you very much. What a place. I've been here before. When we spoke with you before, who knew it was going to turn out this well, though, really? I told you we were going to do a lot of things. Nobody thought it was going to turn out like this. This has been crazy. But it's a true honor to be back at the Detroit Economic Club with the businessmen and women who are really the economic engine of America. That's what you are. You've become more of that since I've been in, a lot more. Factories and plants were going to close, and now they're going 24 hours. I just left Bill Ford. He's running his plant, 150 plant, 24 hours a day, round the clock. It wasn't running that way 2 years ago, I can tell you. But it's the complex that Ford Motor Company so cherishes. It was a pleasure to see that the crown jewel of Detroit auto industry is what they call it, is still going after 100 years. Can you imagine over 100 years? I especially want to thank the president of the Detroit Economic Club, Steve Lorian. Where's Steve? Steve? Where's Steve? Hi, Steve. Nice looking man. Nice looking guy. And board chair Sandy Pierce. Thank you very much, Sandy. Thank you very much. And we have some very special people here. We have a man who's doing a fantastic job. I get angry at him every once in a while, but very, very seldom. Because he's got what it takes. Treasury Secretary Scott Bessent. Scott? Hi, Scott. Hi, Scott. What a good guy. He's got a good pulse, doesn't he? Good pulse of what's going on. Thank you, Scott. He's been great. Michigan House Speaker Matt Hall. Hi, Matt. We did good in Michigan, Matt. We won the whole thing in Michigan, didn't we? 3 times we won. You know that, right? They didn't give us credit the second time, but we won the second time. But we made the last one, Matt, too big to rig. Right? That's what you got. That's the only way you win races in many cases. I got to tell you, it's too bad. I think they should get voter ID. Wouldn't it be nice? The Democrats are totally against voter ID. Who's against voter ID? How can you even campaign? We are against voter ID. How do you not get voter ID? You know what it means, Matt, right? When you're against voter ID, you want to cheat. That's all. There's only one reason you want to cheat, and they do cheat. Yeah, terrible. Michigan Senate Republican leader Eric Nesbitt. Thank you, Eric. Thank you. Look good, Eric. State Senator Jim Ronstadt. Jim, thank you. Thank you. Thank you, Jim. Former Congressman Mike Rogers, who's running for the Senate, and he'll be a great senator. And he's going to be a great senator. He was a great congressman, and then he left and went on to very big things. He did well no matter where he was, and I think they took that away from you last time, I'll be honest with you, Mike. I really do. Don't like to get things going. I don't like to be controversial at all. But they rigged the election on you. Mine was too big to rig. You won, I'm telling you, you won, but you're going to do great this time. He's a great guy, actually. He should be an amazing senator. Thank you. Thank you for being here, Jimmy. Special envoy to Iraq, Mark Savaya. Mark. Hi, Mark. Thank you. Great job you've done. This guy, he negotiates better than anybody around. Thank you. You need it. With Iraq, you need it. You need to be a good negotiator, Mark. I also... How are you police? Did you know the police? You know the rules of law enforcement? Would you like to raise your maces and we're following the law? You know the law?
You are choosing this. You must be weak. You must be coward.
Are you a veteran? Cosplay. You're cosplay for it. You see, I went to fucking war for my country. I started the fucking war. Is that why you did this?
I see each one of you. Shame on you. I see you. You are fighting. But I see you. Shame.
You goddamn
Finally got my gas mask off. Hopefully you got some good coverage there. Man, if you're a longtime viewer of the stream, guys, and if you guys know how to use X and how to make clips off Twitch, and I can trust you with my X, reach out to me. I need somebody who's willing to help me out, make clips real quick as things take place, situations out here happen. That last clip was pretty good, so. I just need help with managing my X account and posting the stuff as it breaks.
Mom, I have my inhaler. I'm not gonna get through it. It's okay. If I see them coming out, I'll go to the back.
picture. Thank you. Yeah.
My mom's worried about me because I have asthma. Well, that's the thing. And I told her, I'm like, if I I looked right over in Midway by the soccer stadium, so it was just like a bus of everybody.
By the way, everybody, there's
people for the Army, the Navy, the Air Force, the Marines, Space Force, the Coast Guard. You couldn't get people. And since right after the election, but especially since after January 20th when we took office, we have now the strongest enlistment we've ever had in the history of our country. We've never enlisted people so quickly, so easily. And we enlist by merit now. You know, we won a Supreme Court case that said you hire by merit. You go to college now by merit. Everything's by merit. Our country became great because of merit. And we have done some job. But think of it, a year and a half ago, we had the worst enlistment in history, and now we have the best enlistment. That things like that don't happen. You might go from the bad enlistment to okay, but you don't go from the worst in history to the best in history. But that's what we've done, every one of them. And that includes police and firefighters. It was very hard to get police. It was very hard to get firefighters, and now everybody wants those jobs. In 4 years of Biden, they secured less than $1 trillion of new investment in the United States. So 4 years, less than $1 trillion. In less than 1 year, I have secured commitments for over $18 trillion from all over the world, the most ever for any country. Think of that, though. They did, and I'll tell you what, had she won, it would be a disaster, because you would have people leave. You would have not had $1 trillion, you would have had $5 trillion, $10 trillion leaving the country, and your welfare would have doubled. When you look at what's going on in Minnesota, is that a disgrace? Is that a disgrace? But we'll talk about that. Under Biden, we had the highest trade deficit ever recorded, losing more than $1 trillion every single year. How about that? It was killing Michigan, and everywhere else in our country was being absolutely destroyed. But in a matter of months, largely because of tariff income and the election result, we've slashed that gaping trade deficit by, in a short period of time, 62, it just came out, 62%. People are stunned. The fake news back there, look at those cameras rocking and rolling. No, the fake news back there is, they're very upset about it, actually, but they're stunned. They can't believe it. We cut our trade deficit in actually 10 months was when the number came out. We cut it by 62%. It's going to go better than that now. The stock market is now the highest in history since the election. We've set all of those records, and I think an all-time record that's so important to me because so many people have them is boosting 401ks and retirement accounts for millions and millions of Americans, people that are in the police departments, the fire departments, people that are construction workers. A policeman came up to me recently, a nice guy guarding me. He's a perfect guy to guard me. He was a massive guy, big, strong guy. He said, "Sir, you made me look so good in front of my wife. My wife thought I was a horrible investor because every time I invested, we lost money. And we have a 401k, and I'm up like 85%. She thinks I'm Warren Buffett. She thinks I'm brilliant. She's now calling me brilliant. It makes my life much easier. I love my wife much more now. She calls me brilliant every time. I said, don't worry, you're going to do even better for the next 3 years. But one of the biggest reasons for this unbelievable success has been our historic use of tariffs. There was the tariff that made America strong and powerful in past generations, and then we got off it and we went to the income tax system. Great going, fellas. You know, we were the strongest in 1887, relatively speaking. That was around the McKinley time, and Teddy Roosevelt and some others, but we were really strong. It was all tariffs. And I know what happened. Some of these countries got together and they say, hey, convince the United States that it's no good, the tariff system is unfair to us. And so some genius, I know who, I don't want to get into it, but some genius said, oh, let's go to an income tax system. So instead of foreign companies and countries paying everything, the people started paying. And then after that, you had a depression, but that was a long time. That was in like 1913, you had the tariff switched into income tax. And then in and they like to blame tariffs. You ever notice they blame tariffs? No, they brought tariffs back in 1932. They brought them back to try and save the sucker. But it was in 1929, because a lot of people, you know, the anti-tariff people. Now, an anti-tariff person is a pro-Chinese person, like Koch. This guy's fought me in every election I've ever been in, and I've kicked his ass. He inherited a lot of money, and I don't know the gentleman. But he fights me, and then he goes out and says, I made more money with Trump than I ever made in my life. And then he supports these other people that were total losers. Gives them a lot of money, but he made more money. Everybody makes money with me. I always made money for people. Now it's tariffs that are making money for Michigan, and the entire country is stronger and safer and richer than ever before outside of that period of time. Now, if they had what was called the Great Tariff Act of 1887 or something like that, and it was a great group of people like yourselves. They picked really smart people to sit on a committee. They had so much money, they didn't know what to do with it, and they wanted to have the money given away. You know, we built the Panama Canal out of tariffs. We did a lot of things. Panama Canal was the single biggest investment, relatively speaking, that this country's ever made. Would be the equivalent of trillions of dollars today. And Jimmy Carter gave it away for $1. It was also the most profitable thing ever built. Thing. In other words, like buildings or casinos or anything, the most profitable thing ever built was the Panama Canal. And brilliantly, Jimmy Carter thought the country of Panama should have it, even though we lost 36,000 people to the mosquito. You know that, right? To the mosquito and a certain snake, which was not a very nice reptile. This was a brutal reptile. You got bit, it was over. It was just like, bye-bye, everybody. We lost 36,000 people. Malaria, the mosquito, and the snake. And he gave it away for $1. Well, at least we got $1. That's better than most of those guys do. We got $1 for that. Most expensive thing ever built, most profitable thing ever built, too. Makes so much money. Every prediction the critics made about our tariff policy has failed to materialize. The evidence shows overwhelmingly that the tariffs are not paid by American consumers, that they're paid by foreign nations and middlemen. And Scott went over that with us before, and they're paid by middlemen. They raise the thing. Countries get involved. They pay them because otherwise they won't have companies. They won't be viable. And we're the big beneficiary. Once again, the so-called experts were 100% wrong, and Trump was right. People of Michigan were 100% right. You elected the right guy. Have you had the other person, everybody? We wouldn't even be having a meeting today, probably. There'd be no meeting. The Economic Club would be saying, like, man, we're doing bad. It's going to be awfully tough to get people to show up. This is going to be tough, the chairman. This is going to not be a good day for us. We don't want to have, let's cancel the meeting immediately. The Trump tariffs have delivered us trillions of dollars of new investment, unprecedented new partnerships on minerals, rare earths, defense, and artificial intelligence, and historic levels of foreign military sales. You know, you have the Supreme Court now going to rule on whether or not we can use tariffs. Can you believe this? A case brought about by people that are China-centric, foreign-centric, but China-centric. I wouldn't want it if I was China either. You know, China's one of our biggest taxpayers right now. China, would you ever believe you'd hear that? And they've been great. My relationship with President Xi has been great, but we have a group that's foreign-centric, China-centric, suing. And we'll figure something out if we don't win, but we should win. I mean, we should win. So great for national security. I ended 8 wars. Think of that, 8 wars. And without trade and tariffs, you wouldn't have been able to end any of them. But they brought hundreds of billions of dollars pouring into the United States Treasury, helped curb inflation, and helped cut the federal budget deficit by a staggering 27%. And that's only for a short period of time. The number's much bigger than that when you add in the full year. And I've told people I got into a lot of trouble because of the fake news back there. I told people, I said, tariff is my favorite word. I said, my favorite word of every word is tariff. I've loved it for 40 years. I came here many years ago. Remember, they said I didn't come here. Then they found out I did. I got an award in Detroit, in Michigan, many years ago, and still have it. They said, it never happened. It did happen, turned out. I didn't notice any apology. But all I did was talk about you're losing your car industry. This was long before I ran for politics. They said you're losing. I said, why are you allowing these foreign nations to take your car? You know, you lost 57% of your car industry. The good news is you're getting it back. But I said, why aren't you using tariffs? I've been very consistent, I will tell you that, for years and years. Even as a private businessman, for years I used to, because I got, for whatever reason, a lot of publicity always. I don't know if that's good or bad, but it happens. And I talk about the importance. But I said recently, I said, tariff is my favorite word in the whole dictionary. There's no word. And I took a lot of heat. They said, what about your wife, your children? What about religion and God? What about Jesus? So I said, all right, it's my 5th favorite word. And since then, I've been fine. They hit me hard, these people, the fake news. They were killing me over tariff. He likes tariff more than his wife, more than religion. He likes tariff more than anything. What a disgrace. So I now call it number 5, and I'm in good shape. That was a rough day. It's my favorite word, and I got killed. Every word, you know, when you go up here, you take a big chance, especially me, because I go off teleprompter about 80% of the time. But isn't it nice to have a president that can go off teleprompter? When you think? Remember the speeches Joe would make? First of all, they'd last a matter of seconds, you know. Thank you very much. You ever notice Joe would always cough before a speech? State of the Union, he gets, ladies and gentlemen. And then it would be like very short. Although the one time they had him spruced up pretty good, remember, he was high as a kite. He was floating, he was up there way up. That was a bad speech. But, hey, he got through it, you know, he got through it. If you call it getting through, this country was so, can you imagine allowing 25 million people into our country, many of them criminals, many of them murderers? Truck business went through the roof.
You said to Iran this morning that help is on the way for protesters. What did you mean by that? What kind of help?
You're going to have to figure that one out. I'm sorry.
How many people have been killed in Iran?
Nobody's been able to give me an accurate number. I have heard numbers from everything's a lot. One is a lot. But I've heard numbers much lower, and I've heard numbers much higher. We'll be knowing. We're probably going to find out over the next 24 hours. I think it's a lot. It's too many, whatever. Truck business went through the roof.
You said to Iran.
I'm sorry. Trump has heard numbers much lower than one. What kind of numbers has Trump been learning? I mean, there are a lot of numbers lower than one. I mean, there's actually an infinite numbers if you keep going out on the decimal point. But what did he mean by that? I've heard a lot of numbers lower than one. Trump knows about integers now. This is huge news.
How many people have been killed in Iran? Nobody's been able to give me an accurate number. I have heard numbers from everything's a lot. One is a lot. But I've heard numbers much lower.
That's true, DJ Lunchbox. Negative numbers. I've heard of negative numbers too. And they're much lower than one. That's true. That's true.
I've heard numbers much higher. We'll be knowing. We're probably going to find out over the next 24 hours. I think it's a lot. It's
You guys know I'm just fucking with Trump. I'm not being mean to the old man. It's funny. It's funny. Technically, he's right. Technically. What is this? All right.
It is time.
Sure. Turn your kids into Antifa. Yeah, great job. Great parenting. Good job. The Chicago Teachers Union doesn't know how to spell governor. Governor. Ah, Jesus. Oh, yes. Governor. Sure. Sure.
Because they said it's too good to be true, but then they realized that I was serious. They were getting them 2- and 3-week approvals. They don't have to wait for 20 years before they get rejected. You know, in the old days, they had to wait for 20 years, and then they get rejected at the end of 20 years. Guys would give up their whole career trying to get one approval, and then they get rejected. In every aspect of our agenda, we're putting America first, and nothing will stand in our way. Nothing's going to stand in our way. Nothing. So one of our top priorities in this mission is promoting greater affordability. Now, that's a word used by the Democrats. They're the ones that cause the problem. The one thing, they stick together. They don't have some of the people that we have. I don't know, it's a genetic thing. It's something in the blood. We got some real losers, mostly great, but I wouldn't use the name Romney because I'm in his sort of territory, so I would never use that name. But all right, I'll use it. They don't have a Mitt Romney that votes against everything. They don't have a Rand Paul that votes against everything. I got him elected twice. He was a stone-cold loser. I went to Kentucky where I won by a lot. I did a rally for him. Then I did another rally, he won. Then I went the second time, he won. Then he votes against all the time. It's just crazy. I don't get it. Then you have Lisa Murkowski and you have Susan Collins. Disasters. And you had a gentleman from Indiana that I don't believe it, Todd Young, he voted against. And you'd say, why are you voting against? They can't give you an answer. They're unable to give you an answer. It's like, why are they against the attack on Venezuela? They're against the attack after they found out it was the most successful attack, probably the most talented, most brilliant tactically attack that we've had maybe in 100 years. And they're against it. Why? You know, it's one thing if the attack failed. I'd probably do that too, a change. I'd be in favor. Then if it failed, I'd say, I told them not to do it. That's what they do. But here we have one of the most successful attacks ever. And they find a way to be against it. It's pretty amazing. But it's a shame. And we have some others, but not many. We have a great party, but we have people, the Democrats, whether you like them or not, they stick together like glue. They have horrible policy. Thank God they have horrible policy. Because they're smart, they're evil, they're vicious, but they're bad policy. For instance, you could be a genius and try selling men playing in women's sport. You can be a genius, try selling transgender for everybody, open borders, let the world come in, let the world's prison population come into the United States, including all of the murders, 11,888. That's what we're trying to get out of Chicago and Minnesota and these places. So they stick together, which I admire because I'm a very loyal person, but they have horrible policy. Can you imagine if they had good policy? They were on this morning talking all the reasons that men should be playing in women's sports. They had a football guy there, flag football. This guy was like 6'6". He weighed 290 pounds with zero body fat. And they had a few young women. They were the size of his leg. He wouldn't have had to run. He could have just walked. They couldn't have done a thing about it. 10 of them would have to jump on him that wouldn't have had any impact. I don't think he would have been like a fly. It's so ridiculous. It's so demeaning to women. It's so demeaning. Look at the weightlifting records. I mean, the record got beaten by 112 pounds, a record that stood for 18 years. 1 ounce they'd put on stood for 18 years. Guy comes along who was a poor lifter as a man. He was at the lower portion of the class. Comes along and broke the record by 112 pounds. Think of that. They've fought for years to beat that record. How about the swimming records? I mean, you can go to sleep during the time the man comes in and the woman. You can go take a nap for a little while. How about the long-distance race that took place not so long ago? Long distance, these marathon deals. They had top men, top women. The man came in. The woman came in 5 hours and 14 minutes and 36 seconds behind the man. Think of it. You're waiting. The man comes in. Now you're waiting 5 hours. What do you do if you're the parents? You go home and sleep for a while. Who the hell wants that? It's so demeaning to women, and who are great athletes. It's so demeaning to them, and it's right now in the Supreme Court. I can't believe it would even go to the Supreme Court. I mean, could you imagine 20 years ago talking about men playing in women's sports? They'd think you're crazy. Or transgender for everybody? If you said there will be no mutilation on children, that's one of my standing lines. We will not allow the mutilation of a child. Can you imagine having to say that 15 years ago? People would say, is that guy crazy? Of course we won't. But we're living in a different time. It's a crazy time we're living in. After real wages plummeted by $3,000 under Sleepy Joe Biden, real wages are up by $1,300 in less than 1 year under President Trump. For construction workers, wages are up 1,800. Don't forget, they were down 3,000. Factory workers over $2,000, and for many other workers, over $5,000. And I just gave the military, because we're doing so well with taking in so much money with the tariffs, I just gave them $1,776. You saw that, right? Did you see that? They had 75, and I said, you know, if you had one more dollar at 1776, they said that was a good idea. We could afford one more dollar. We gave them 1776. Meanwhile, grocery prices are starting to go rapidly down. Rent is down, airfares are down, hotel rates are down, cell phone prices are down, and we're just getting started. But more importantly than going down, our growth is through the roof. It's way up. Among my first acts in office was to end the radical left war on oil and gas and stop the crusade to kill American energy, and frankly, to open up cars so that you don't have to have an electric car. I love electric cars. I think they're great. I like Elon a lot. I don't think he was too happy with my policy of opening it up, and I can understand that. But I've been saying it for 4 years. They wanted everybody to have an electric car in a very short period of time. There was no way to build the stations. There was no way to get it done. I want you to have gasoline-powered cars. I want you to have electric. I want you to have hybrids. I want you to have everything. Hydrogen, I don't know about. I'm hearing it's not testing so well. It's fine, except when there's an explosion, you're a goner. Now, have you heard that with hydrogen? I have one guy who's trying to sell hydrogen, and I say, yeah, but, sir, that only happens 1 in 100. Oh, great. When it happens, they find the body like 300 yards down the road. So I said, I'll pass on hydrogen. Maybe there's something I don't know about, but is anybody in the hydrogen car business? Gasoline is now under $2.50 a gallon in 17 states and under $2 in many places. We have some states it's $1.95, $1.99, $1.97. As we speak, these are gas stations, and think of that. We have gas stations in the Detroit area where you can fill up for less than $2.30 a gallon, whereas 2 years ago it was $4.50, and in many places it was way over $5. Think of that, $2.30. You see it. That's like a massive tax cut, which we gave you under the great big beautiful bill, by the way. No tax on tips, no tax on Social Security, no tax on overtime. And with our extremely successful operation in Venezuela earlier this month, that number soon is going to go lower because we're going to have a lot more energy. We're going to have a lot more, as opposed to a country that's going to be totally shut down. No fuel, no gasoline. And it's, you know, they say it's got more than Saudi Arabia. Who knows? It's got a lot. And by the way, to all Iranian patriots, keep protesting. Take over your institutions if possible. And save the name of the killers and the abusers that are abusing you. You're being very badly abused. If the numbers are right now, I hear 5 different sets of numbers. I hear numbers, look, 1 death is too much. But I hear much lower numbers, and then I hear much higher numbers. But I say save their names because they'll pay a very big price. And I've canceled all meetings with the Iranian officials until the senseless killing of protesters stops. And all I say to them is help is on its way. You saw that I put tariffs on anybody doing business with Iran. Just went into effect today. And I say make Iran great again. You know, it was a great country until these monsters came in and took it over. And it's all very fragile. It would have happened to us, I'm telling you. If I didn't win this election, it would have happened to us. In the coming weeks, I will be laying out even more plans to help bring back affordability. And again, remember, that's a fake word by Democrats. Prices were too high. They caused the high price. They never want to talk about affordability. They always go, this is an election about affordability. I say, they caused it. But they're good at that stuff. They're good at that stuff. They're fake, and they're good at that stuff. It's an election about high prices that was caused by the Democrats and that I brought down a lot. And remember, when you see energy coming down like I brought it down, and gasoline coming down, that brings everything else down. It's so much bigger than any other factor. When gasoline gets to be $1.99 a gallon, everything comes down. The donuts come down, the truck that delivers the donuts, the stove that makes the donuts, the whole thing, it all comes down, and it's coming down much faster than anybody can even believe. And remember, though, I always say, because normally when that goes down, the world comes down. That's the bad way of bringing it down. Our growth is through the roof. So I always want to say that whenever I say prices are coming down, but our growth is going way up. Two beautiful events, the exact opposite of the Biden administration. As part of those efforts at Davos next week, I'm going to provide much more detail about our housing policies so that every American who wants to own a home will be able to afford one. We have some great things happening with housing, as you know. You saw the $200 billion buy-in on bonds and mortgages. This will include a ban on large institutional investors buying up single-family homes all over the country and making it impossible for people to buy a home. And I've also announced that the U.S. government is purchasing $200 billion of mortgage bonds to bring down mortgage rates, and it's had a huge impact. It's already started. And just last week, the average 30-year mortgage dropped below 6% for the first time in many years. It's coming down very rapidly, and that's not with the help of the Fed. If I had the help of the Fed, it would be easier, but that jerk will be gone soon. In addition, I proudly called for the credit card companies to cap interest rates at 10% for 1 year because they're getting 28% and 30% and 32%. And it's unfair. The rates are way too high. To provide further relief to hardworking Americans, we'll also be confronting one of the biggest factors in driving up prices, the monstrosity known as the Unaffordable Care Act. You know what that is, right? It's Obamacare. It's a great name, Unaffordable Care Act. Nope. Did anybody ever think of that one before? It's true. It's the Unaffordable Care Act. Obamacare was a gift to make health insurance companies rich at the expense of the American people. In particular, the so-called enhanced premium tax credits were a corrupt payoff to the insurers, whose stock prices went up more than 1,000% after Obamacare was signed. I want the same money I want it to go directly, very simple. I want the money, those big amounts of money paid for by the government, to go directly to the people so they can buy the health care that's right for them. They can negotiate their own deal, health care savings account, but they'll buy their own health care. And everybody loves it. That's why later this week, I'll announce our health care affordability framework that will reduce premiums for millions of lower drug prices, delivering price transparency and demand honesty and accountability from insurance companies all over the country, all over the world, actually. Health care costs will come down very fast with my most favored nation executive order. We're doing most favored nation drug prices. When we would have drug prices stay the same, everybody thought it was great. They're going to be coming down thousands of percents. We're standing up to special interests and slashing prescription drug prices by 300, 400, 500, and even 600% and more. I mean, think of that. On that alone, we should win the midterms in a landslide. I'm doing favored nations. The country that pays the lowest price in the world is the price that we're going to pay. And we got that because of tariffs, because I said to the countries they wouldn't approve it. The drug companies were tough, but they were fine. But they said the countries will never do it because you have a pill that sells for $10, you have to sell it for 20 or 30, so you'd have to double or triple the price of their health care there for prescription drugs. Ours would come down from $130 to $20. Theirs would go from 10 to 20, the world being a bigger place. And it was unbelievable, but the countries wouldn't do it. So I called the countries. I said, if you don't do it, then I'm going to put a tariff on you. And the tariff's going to be 20 times more than the cost that you're having to pay for fair health care. And every one of them said, sir, we agree with you 100%. We would be honored to do it. It was really rather amazing. We could never do it. So think of that. You have most favored drug prices. Your drug prices are going to go down like from $100 to $10. Nobody can believe it. And we can't get the fake news to write about it. It's the biggest thing to happen in medicine. It's the biggest thing to happen in healthcare. And I cannot get the New York Times, I cannot get anybody to write about it. When we got it done and we announced it, it was on a page way in the back of the New York Times. Same with others. They don't want to talk about it. You know why? Because it's so good. It's the biggest thing to happen. Over the past 12 months, almost every promise I made to you right here in 2024 has been kept. I've kept all my promises and much more. I mean, I've given you much more than I I gave you promises, and I produced much more than I said I was going to produce. I gave you the largest tax cuts in American history, cutting taxes across the board in the great, big, beautiful bill. And as I told you, I mean, who would have gotten you no tax on tips, as I said before, no tax, I say it over and over again, no tax on overtime, no tax on Social Security for our seniors. Any senior should be voting for us because the Democrats won't do this. It doesn't work for them. And we also made interest on car loans fully tax deductible so that when you go out and buy a car, if you have a mortgage or you get a loan on a car, you're allowed to deduct interest for the first time ever. That's never happened before. But only for cars that are stamped with the beautiful words, made in the USA. In other words, we're only letting that take place if the car is made like in Detroit or in the USA. Our tax cuts also provided 100% bonus depreciation on all new equipment and capital investments, meaning that for any manufacturer looking to bring production back to America, you can write it all off, everything, not in 38 years, not in 44 years, in 1 year. You write the whole thing off in 1 year. That's the biggest thing there. I think that's the biggest thing. That's the big job producer. And I've cut an unprecedented number of burdensome regulations. We're number one in the history of our country in cutting regulations. I promised to cut 10 old regulations for every one new regulation. So if we put on a regulation, the only way I'll allow it to happen is if the secretary, like Scott Bessent, cuts 10 old regulations. But instead, last year we actually cut 129 regulations for every one that we put in. Think of that. So nobody's ever cut regulations like I have. I terminated the insane electric vehicle mandate and ended the war on internal combustion engines. Once and for all, those engines were gone. And some people like them. And if they like them, great. And if they like electric, if they like any form of propulsion, any way you want to propel your car is okay, except for a couple of them, as I discussed. So I permanently stopped Joe Biden's ridiculous CAFE standards. You know what the CAFE standards are? They're standards that make it impossible for you to build a car affordably. They make it impossible for a car to really work right. The CAFE standards sound so nice. The CAFE standards, it's environmental standards that are impossible to meet. And we're canceling the EPA's absurd tailpipe emission standard, one of the worst ever. And I revoked the California emissions waiver to stop San Francisco communists from regulating automobiles all over our nation, all over our world. Boy, I have done so much for the car industry. It's crazy. Nobody thought it was possible to do this. And that's why your industry, and not everybody's in the car industry. How many people are in the car industry in this room, in one way or another? That's a lot, relatively. It's not bad. Another urgent priority for bringing down the cost of living is to stop the colossal fraud that is bleeding American taxpayers absolutely dry. The fraud being committed by the Somali population in Minnesota. Have you heard of them? They're lovely people. Is monumental. And California, Illinois, New York, and others are just as bad. Our country has been losing over $500 billion to fraud every single year, but those days are over. We have the best group you've ever seen assembled going after fraud. In Minnesota, we're cracking down on the Somali scams, ending the brazen and shameless theft of taxpayer dollars. Well, it's going on in Maine, too, with Somalis. You know, and they don't take our ships anymore. You know why? We hit them with the same missile that we used to hit the drug dealers coming in with the boats. You know, we have drugs coming in by sea down 97%. You've seen that? 97%. And we're trying we're really trying hard to find out who the hell is the other 3%. But we have them down 97%. And we're going to start hitting them by land, too. The hard part is done. By sea, nobody's coming. It hasn't been great for the fishing industry, however. Those that have a fishing boat, they're having a hard time getting customers. But you can't have everything. Nobody wants to go on boats. Nobody wants to go like 25 miles an hour. When you see a boat with 5 engines on the back of it going 65 miles an hour, and it's loaded up with hundreds of bags that you see cellophane with white, typically it's not fishing. How about the couple of submarines we took down? We took out 2 submarines, and the Democrats say they were fishing. No, they were submarines. They were actually, they build a very fast, it's a drug-carrying submarine. They have a lot of money. And we took them out, and the Democrats claimed that they were fishing. We shouldn't ruin people's beautiful fishing journey. It's unbelievable what we have to go through. It's really a shame, actually. We froze it all, children's payments to those states that we're talking about, and we will now require proof of attendance in order to receive federal funding for child care or any of that. How about all these child care places in Minnesota where there is no children? They go there, they get paid millions and millions of dollars. The biggest operation in all of Minnesota had no children, and we paid